Any mention? Supplementary list, item number 1.
Your Lordship, bringing up this matter may be taken up after some time.
Have you seen the office noting?
Your Lordship?
Have you seen the office? Just show her. You don't have the impugned proceedings.
Your Lordship.
What is the reason?
Your Lordship, it's learned senior will be.
Well, it's connected to item 21.
What is 21?
It's the same college, madam. Item 21 is Shri Hidayatullah Qazi vs. State of Meghalaya, which deals with Qazi and Zaman College. So they are claiming that a certain governing body has been appointed, and
Where
this
is the Qureshi is here?
maybe it may be taken up as item.
Item number 2.
After some time, Mr. Yes.
Main list, item number 1.
District Council, my friend is coming.
Please, Your Lordship. Your Lordship, my senior is on his way, Your Lordship. He's still stuck in traffic. Your Lordship, I just called him, Your Lordship, to ask for instruction. Your Lordship, if this matter can come up next week, Your Lordship.
He's stuck in traffic. He's at home or he's in the car?
He's in the car, Your Lordship. On his way, Your Lordship.
The matter's been adjourned for too long. It's for admission hearing.
Admission
Yes, Your
hearing.
Lordship.
Who's for the private respondents?
Yes, Lordship.
Mr. Cream is my friend.
Be
I
Cream.
do not
Where's
see
the
him
Cream?
in the room.
I didn't see him.
We'll take after some time. Let's see. Hope he makes his way through the traffic. Yes.
Your Lordship, my instruction is it can be taken up next week, Your
Let
Lordship.
Mr. Cream come. We might admit him.
Your Lordship.
Item number 3.
3 also direct senior.
We'll follow up sometime.
Item number 4.
Here in this matter, Lordship, I will not file the affidavit, Lordship, because the only grievance against the state is the non-disposal of the representation.
Where's Mr. Nyota?
Your Lordship, I appear for the private respondent here, Lordship.
Yes.
Your Lordship, I have received the inputs here, but Lordship, I seek some time for translation, Your Lordship. Because there are many papers in
what? In Hindi?
Bengali language.
Mr. Paul Pasque, respondent number 3, submits that due to please give further time to file affidavit. Just after 3 weeks, yes.
2 weeks, Your Lordship.
3 weeks, take 3 weeks. None appears we have the petition.
5.
My lord, I seek some more time, my lord, to file my rejoinder affidavit to the private respondent's affidavit, my lord.
What are 5 to 7? You won't file affidavit?
They filed, my lord.
When they filed?
My lord.
Okay.
I received on 6/9/2023, my lord.
Okay, affidavit has since been filed on behalf of respondent 5, 6, and 7. Ms. Hassan, please allow further time to file the rejoinder.
3 weeks, my lord.
Respondents. Just after 3 weeks.
Item number
Highly
6.
obliged.
6.
Connected,
Same,
my
my
lord. Same, connected, madam. Hello.
7.
May it please, Your Lordship.
Yes.
Your Lordship, we have just received the certified copy of the order sheet yesterday. Your Lordship, I pray that 2 weeks' time may be given to file a compilation.
Your name?
GC Marbo.
MSGC Marbo submits the third copy of the sheet. She prays the Lord 1 week's time to file the same.
Oblige.
8.
Do other files. She prays for the Lord 1 week's time to bring the same record for this court. Yes. Everyone for the case here. Good for the respondent. CRP. Yes, you with Mr. Jindal.
Yes, George.
Where's the respondent? You appearing for the respondent?
You have the petitioner. But
No, because the lady just stood up, I thought it's was it for today? It's for what today? Why did the respondent ask me listed today?
Your Lordship, we have been informed that they would be taking adjournment, but you couldn't find him. If your Lordship would kindly fix it after a week time.
Your name?
I Kharmujai.
Ms. Anukhuja is present behalf of the petitioners, none is present behalf of the respondent. In interest of justice, this matter after 1 week.
9.
Your Lordship, this matter pertains to non-payment of outstanding dues.
Your Lordship, on the last occasion, respondent 4, which is us, we've been given further 2 weeks' time to file affidavit. And I've also submitted on the last occasion, Your Lordship, that the affidavit was awaiting the approval of the ministry. However, information has come back that the ministry has not approved the affidavit. So the exercise may take longer, Your Lordship.
How is the court to know? Just on your submissions?
Your Lordship, I'll try to produce Your Lordship on the next given
What
date.
about state?
We're fine already, Your Lordship.
What's the amount due?
Tune of 3 crores, Your Lordship.
MSS Rumthau submits that the affidavit that has been drafted and sent for vetting has been disapproved. Such please have allowed further 3 weeks time to obtain instructions of fresh and file affidavit just after 3 weeks. We have allowed.
10.
Please, Your Lordship. On behalf of respondent 1 to 7, we are praying for some further time to file affidavit.
Time for what?
File the affidavit, my lord.
What's the matter about?
It's a land matters, Lordship.
Is a patta matter?
Yes, Lordship. Between the two brothers.
Where's the... You have been fight respondent?
No, only 1 to 7, District Council.
What about number 8?
Number 8.
Has it been served?
The notice has already been served, I think so, Lordship.
Has it been served?
Let them file a state.
You've taken steps. Have you taken steps on number 8?
Yes, Lordship.
1 second. Oh, where's the WPC 83? Is it today also?
No, that has been withdrawn. It was in fact dismissed with cost.
That filed by Mr. Sheikh only.
No, Mr. B then. This is filed by Mr. Sheikh. This is on behalf of the second brother.
Okay. It appears from the order sheet that Mr. Oh, sorry, 1 second. He never appeared in this matter.
No.
It appears that though service has been effected upon number 8, none has appeared so far. Stop. Today, Mr. S. Deb, on behalf of respondent 1 to 7, prays they will allow further 2 weeks time to file affidavit. Yes. According 2 weeks time to grant it. If no appearance made on behalf of respondent in next date, the same shall proceed ex parte against the said respondent.
Exam 11.
Your respondent are yet to file affidavit.
Where's
I'm praying for a week's time, Lordship. Final last opportunity, Lordship.
Former respondents, Lordship.
you won't file? 1, 2, 3? You're not going to file. Okay. Mr. A. Mumin. That's already been recorded before. Recorded before you're not filing affidavit. What about number 4? Has that appeared?
Till now, not yet, Your Lordship.
Mr. S. Chanda, on behalf of respondent number 5,
Lordship.
please then be allowed further. How much time?
1 week's time.
1 week's time to file affidavit. It is noted that respondent number 4, who has also been served, has not entered appearance as yet. Just after 1 week for affidavit and for appearance of the respondent number 4.
Item number 12.
Yes.
May it please Your Lordship. Lordship, in fact, on the last occasion we prayed for time for filing a rejoinder. But after going through the affidavit, Lordship, it appears that a proper affidavit from the department is required. This
How
is
do you say that?
Lordship,
if the affidavit is lacking, that do works to your advantage.
Rejoinder, it may be.
No, against this affidavit, I don't think a rejoinder, because this is a matter of a
proposal for hearing. Yes, Mr. S. Deb submits that on examination, it appears on the rejoinder will be necessary to the affidavit filed to respondents accordingly.
Because this has been filed only on behalf of respondent 3. This is the directorate.
Doesn't matter.
Yes, put the blame
only
on
one
the
affidavit you file, you won't file anymore.
Yes, on behalf of
Very good.
respondent
Yes,
three.
this is a matter for hearing.
13.
Lordship, 13 is a similar matter there. We are awaiting affidavits.
We have already sent to the department to sign.
13? We have longer display.
After 2 weeks, will be filed.
This is 13. What's the other corrected matter? Is there any corrected matter?
Yes, similarly.
2 weeks time to file affidavits.
2 weeks time.
Yes, as prayed, Mr. A movement for the respondents is allowed for the 2 weeks time to file affidavit. Yes.
Much obliged.
14.
Lordship, in this, I need some time, Your Lordship, to file my affidavit.
You already asked, took 3 weeks time.
Your Lordship, I got the price command, but it is not clear.
You got the?
I got the price command, but instruction is not clear.
What?
Instruction whatsoever is, it is not clear.
So that sections is blank, the paras comments you got? Actually blank.
Your Lordship, matter should be clear, not this.
Mr. Ademar submits that the paras comments received are not, are what you saying? Are not clear.
It is not complete.
Not clear
complete.
and incomplete. As such, he prays them to obtain proper instructions and to file affidavits. So please allow this after 2 weeks.
15.
Lordship, I may be given 2 weeks time to file my counter, Your Lordship.
How many times you prayed?
I think this will be, I think, around 4 times. I think.
Around 4 times. You got instructions?
I got the instructions.
Then let's see what instructions you have.
Oh.
What did he say? If on based on instructions, if they are, letters from the department, we can dispose of these matters without waiting for affidavit also.
This matter need to be heard because these are little complicated issues, Your Lordship.
Complicated, so this court is not competent to hear it right now.
No,
Okay.
on my part.
Mr. H. Abraham allowed 2 weeks for the time to file affidavit. Yes.
16.
May I please, Your Lordship? Your Lordship, I pray for another 1 week time to file the rejoinder of affidavit.
Yes, yeah, MSB soon.
Yes.
MSB soon prays for not further 2 weeks time to file rejoinder. Just after 2 weeks, yes.
17.
Your Lordship, in this matter, the state respondent, are supposed to file their affidavit. Your Lordship,
Who's applying for the state?
Mr. A. Gurung, Your Lordship.
R. Gurung and S. Syam.
Yes, Your Lordship.
You won't file affidavit?
We'll file, Lordship. I'll obtain the instruction and file.
For state upon praise for further 2 weeks time to file affidavit. Yes, thereafter also.
Much obliged.
18.
Lordship, in this matter, I pray for 2 weeks time to file the affidavit, Lordship.
File?
2 weeks to file the affidavit.
Okay, Mr. H. Karmi prays for 2 weeks time to file affidavit. This also.
19.
May I please, Your Lordship? Your Lordship will be filing our affidavit in the course of the day, Your Lordship.
Very good. MSS Salam submits that the affidavit and behalf of response will be filed in the course of the day, just after 2 weeks for rejoinder of any.
Obliged, Your Lordship.
20.
Your Lordship, I'm appearing on behalf of Respondent 4 and 5. I've received the instructions, Your Lordship. If I can quickly brief Your Lordship with the facts. Now, Your Lordship, the petitioner herein was initially appointed in the state government of Meghalaya, and he had come to Nigrims on deputation in the year 1989 and subsequently got absorbed in the post of peon in the year 1999. He attained superannuation on 30th 9 of 2021 and was subsequently released from service. And the petitioner herein is now claiming the pensionary benefits, gratuity amount, leave encashment, which has all been paid, Your Lordship, by the institution. If I may apprise Your Lordship with the details of the amounts that were paid.
You're aware of that, Mr. Marpan?
Your Lordship.
I've already confirmed from the petitioner, yet not received.
The monthly pension of amount rupees 19,900 plus applicable dearness relief, retirement gratuity rupees 5,60,384, leave encashment of 300 days rupees 5,09,440, commutation of pension amounting to rupees 7,82,691, GPF amount rupees 4,46,000.
You file affidavit then.
Your Lordship.
Ms. Asram submits that instruction to be received and that the act will be filed within
2 weeks, Your Lordship.
2 weeks. It is further submitted also that as per the instructions, whatever amounts due have since been paid to the petitioner. Stop Mr. S. Marpan to obtain specific instructions.
21.
In this regard, stop.
Please, Lordship.
Yes,
Lordship, this case is filed with a very limited prayer because the governing body of the... Yes, sir. In the affidavit I have seen, Lordship, actually when the committee is constituted, it should be sent to the director, to the NEHU first. And the director of NEHU, they will send to the director of higher and technical education. Now it has been sent. Annexures B, page 18, Lordship. Page 18 is the letter.
The affidavit?
In my petitions.
So the steering committee is also, there's a complaint against that.
Yes. So now,
it has come by new motion today.
No. Yes, because here my case is that let the director examine the matters. Suppose if I have submitted legally through the proper channels, because there is steering committee, they have directly submitted to the directors, which is not permissible. The principal of the college is a very important person. He is the one, he has to submit to the NEHU, and NEHU will, after inducting 2 representatives, then they will send to the director for approval. No, this Lordship, the case, if the director may examine the matter and dispose of the matter after hearing both the parties. I'm not saying to me.
The motion, where's that motion? Who was appearing? Where's Esrum Thao? We take off some time, Zukuriki.
Yes.
Because it appears that, like she says, correct. This matter is connected to your motion. Where's Dr. Mosika?
Your Lordship, I think he's still on legs, Your Lordship.
So when he comes, we take up this matter.
22.
Your Lordship, I'm yet to receive instruction, so if 3 weeks time may be allowed.
What about number 5?
1, 2, 3 and 4.
Yes, Your Lordship.
Receive notice?
Not yet, Your Lordship.
Yes, you're Mr. Lato.
Yes, Your Lordship.
Mr. Lato GAS 4124 prays for and is allowed further 2 weeks time to send affidavit stop. Office note indicates that notice on number 5 is yet service report as well as yet to be received. Just after 3 weeks for affidavit for service report for appearance of respondent number 5.
Much, ma'am.
Second call. Main list item number 1.
Lordship, I just want indulgence for next week.
No problem. Only that time nobody was here. Mr. Karim was not here also. The matter and issue should be admitted then. It's for admission hearing, correct? But you had some objections.
I had very basic points that the locus, the issue of locus, whether it's an aggrieved person.
He may raise also. He may, even if he admitted, he may raise those whatever question from their side. So he's fixing the matter again and again.
He's not prepared today.
I just so happen I'm not ready.
Just after 1 week as the senior counsel, we have respondents number.
Respondent
1, 2.
1, 2, and
my friend.
1, 2, 3.
Yes, seek some accommodation.
Item number 3.
Shall we?
My lord, this relates to creation of a new village.
This for orders or for?
Yes, also for admission hearing.
Yes.
Admission hearing. My lord, this the village, writ petitioner village, was created in 1990 and recognized by the CMC.
1990.
1990.
Okay.
Continued to exist in 2003. The district council has recognized the village. In view of that, my lord, the writ petitioner approached before the elsewhere Guwahati High Court, and the Guwahati High Court passed an order.
1990.
1990.
Did you recognize 2013?
2003.
2003.
2003.
Okay.
And they approached before the Guwahati High Court.
Yes.
Guwahati High Court has remanded back the matter, holding that the right to be heard was not given. Therefore, district council should address after hearing both the parties. So both the parties were heard, and district council 2006 decided that this creation was correct.
That?
The creation of a new village was in accordance with law.
This Mao Sao Mini.
Mao Sao Mini.
Okay.
Then, my lord, this village continued to exist in 2018. That is after 28 years. The private respondent, Eupneo clan,
yes,
who were also a party in that earlier proceedings, raised an objection again and urged the CMship to recognize it, amalgamate it together, merge a club together, and make it as one. Now, district council and the CMship accepted that contention, claim, and the writ petitioner village was considered again merged with the parent village. That is the issue, my lord. Now, may I take a lordship attention to few of the annexures. Page number 28.
Yes.
My lord, this is the order passed by CMship at that point of time. May I take to read lordship with permission. Request from the people of the Mao Sao Mini village stated such over the report mentioned above, and the Som Sardar and his members can no longer constitute one village under Mao Sao and Mao Sao Mini.
The parent village is Mao Sao.
Mao Sao. Mao Sao. Therefore, the same along with the members of the Hima went to reconcile on 1st August 1989. And from that day onwards till today, so on the Mao Sao Mini and Som Sardar cannot settle the matter any longer. Meeting was called under the office of the CM to reconcile many times, but no longer interested to reconstitute as one. Therefore, the CM along with the members under the Hima felt the need to give the full-fledged Sanat Sardar to the Mao Sao Mini. To you, Sri Sansat, is the head Linkhoi, Vice Sansat. So the committee were formed and Sanat were issued to them. You, the Sardar, along with all the members of the Mao Sao Mini.
This is given by the CM?
Yes, by the CM. Can be governed by holding the rule books instructed right from 1953 till today without any biasness to anyone falling under the jurisdiction of the court or your area. And this Sanat shall function from today till the end of 5 years. And the end of 5 years, you will renew if the people are still interested in electing you.
Yes.
But with regards to the land, you shall not interfere with the management of the manager Eupneo land. So in that new village, Eupneo land is there. So you don't interfere with that, but you can run your own village. That was given, my lord. And my lord, page number 31 was the Sanat was renewed again. Page number 31, my lord, is issued by the CMship.
Okay,
my lord. And this was continued, my lord, regarding
what?
My lord.
Body under the.
Yes,
okay,
my lord. And page number, my lord, 33 CM ship directed the.
No, okay, come to 2003 then.
My lord, come 2003.
So, okay, fine, your village is established, it was recognized.
Yes.
The CM gave you recognition and issued standard to you.
Yes,
right. The next.
My lord, may I come to the page number 45 straight away?
Okay.
The High Court order.
Yes.
And now
45 or 47?
My lord, 45, my lord, Annexure 6.
Okay.
My lord. Respondent number 4, my lord, is represented by the Mausau village. Now, District Council impugned order say otherwise. Now, the order, which may read a short order. Well, heard Mr. Such, learned counsel for the petitioner, and Mr. Such, learned standing counsel for the District Council. The village of the petitioner, Mausau was recognized as separate entity since the year such. The boundaries of the village also earmarked thereafter by a letter dated such. The Pumba respondent CM of Milim has confirmed the appointment of the petitioner as headman of the village as well as the member of the village darbar. While the village was being administered as such, with the petitioner as headman along with the other village darbar, the respondent number 3, executive member Ilaga administration has issued an order dated such, which was intimated to the pro forma respondent CM of Nomposapo CM ship by a letter such from the secretary in charge such. The case of the petitioner is that before passing such order, no opportunity was given to the petitioner of being heard, and the order was also passed without any authority from the executive committee. The District Council, which is the competent authority.
Yes, okay. Dispose it off and
dispose it off. So this was the, my lord, order dated 11-3 was the recognition of the village. Now thereafter, my lord, the District Council seized the matter again and heard all the parties, page number 51.
Yeah.
My lord.
And what is Annexure 7? What is Annexure 7?
Annexure 7, my lord. This is the order passed by the District Council after hearing all the parties. And now, my lord, serial number 2 is the Mausau village. And yes, number 4 is the intervener Euphenio clan.
Okay.
Secretary of the clan was intervened and heard the matter. After hearing it, my lord, may I just
what does it say?
My lord, may I come to the last parameter. As such, apart from the above, the executive committee, after careful remand, have ordered that the Mausau mini village recognized as one of the complete village within the Hima Nomposobo, and also agreed to the election of three such. So this was communicated. Now the order passed by District Council is available in page
No, this is the 51. This
is a communication given by the Joint Secretary. The main order is page number 54.
Page?
54.
Okay.
54.
This is 2005.
Mine.
Okay.
Well, now it's a bit lengthy order. May I come to the page number 55, second para, to save lordship time. According the matter was fixed for hearing on such, and both parties turn up. On the said date, both the parties have agreed to file their respective written argument fixing such. Nevertheless, such written arguments were not received even after expiry of the such. From the face of the written argument put forth by the such, writ petitioner read with enclosure attached herewith, it will be apparent that the CM of Nomposopo had given permission and recognition towards creation of the Mausau Mini by carving out of Mausau.
Okay, last paragraph decision of state Mausau. Yes. We confirmed General Bar had a 96, right?
Yes.
Okay. Fine.
So this was confirmed. Thereafter, my lord, Mausau village also, even the Yopuneo clan, they never filed appeal. Matter resolved there. Yeah. According to me, matter attained its finality. Yes. And this was continued, my lord. And thereafter, well, may I just come to complaint, my lord. Page number 79. That is after 28 years of the existence of the independent village. Complaint crop up again by the same Yopuneo clan. This is the complaint addressed to the CM of Milling. The CM of Nomposobo. I'm still corrected. Now, may I just come to the point that the interference from the villagers of Mausau Bibi and Mausau village who resides together within the plot of the village, that it became impossible to bifurcate the boundaries of the village administration. The local villagers under the land of Sunset clan at Mausau are mostly the owners of the land other than some houses who just came to stay, who are not from the Yopaneo clan. Therefore, the disputes within the village had influenced the smooth administration, even the clan. So these are the objection raised by the other
what
side.
happened?
And thereafter,
this was dated when this out 18.
2018.
18. Okay.
2008.
Then?
Now, in page number 83, my lord, 83, the headman of my village, my lord, he had written this letter expressing his personal view. And the district council and the same ship was treating that this is the voice of the entire villages, which is not. My lord. Then thereafter, the village continued to exist, and the district council, my lord, asked for
what
inquiry.
did he say about this letter, 83?
Madam.
What did he say about this letter, convey of this letter?
Madam.
This is, subject is okay, fine. It's like the demand for only one village. And then what replies, what does it say here? You don't translate copies here?
Well, I'm so sorry that the translation copies. You see this? No, it's different. But I'm stands correct, my lord. Translated copy is missing here. But this is the content. But I'm sorry. The content is, my lord, as I informed that content is the.
Go to pass order and Khasi also then.
No.
Just because we can read the next year. Then we'll pass also.
So, if lordship permits me to escape this
Then
for the
you
time
should
being.
have. Then you should have. Before starting the matter, you should have detected this. This is very important. If we say that it's taken to be the voice of the people, and all the earlier decisions overturned because of this letter.
But along with this, other reports.
Whatever it is. It appears that annexure 16 of the petition is in vernacular language and not yet translated. Sorry. This is very unfortunate.
Okay.
Yes. The court thing of disposing of this matter is petitioner permitted to file a translated copy within 1 week. Yes, just thereafter also.
Supplementary item number 2.
Yes. Where's Mr. Sen?
May it please your lordship. This is the case, my lord, where, my lord, a license to operate the weighbridge was granted to me, my lord, for 3 years, due to expire, my lord, on 25th May 2025, your lordships. Now, my lord, when the license is subsisting, my lord, they issued an order, my lord, stating that the license is only up to 30th September 2023. That is also without any show cause, without any opportunity of hearing, my lord. Now, my lord, if I can briefly apprise your lordship, my lord, how this, my lord, so far I am concerned, how I started the operation of the particular weighbridge, my lord, that is called Amsarin weighbridge, your lordships. This is in the Juai Dakia highway. Now, my lord, in the year, your lordship, 2009, the government of Meghalaya formulated rules, my lord, which is called, my lord, Meghalaya Weighbridge Maintenance Rule 2009, your lordship. Now, my lord, this was, my lord, framed in pursuant to the power, my lord, under section 138, my lord, of the Motor Vehicle Act. That is, my lord, power has been delegated to the state government to make rules with regard to controlling of traffic, and, my lord, to check, my lord, the limit of weight the vehicle is permitted to carry. That was the main purpose. Now, in the rule, your lordships, it categorically provides either the government of its own can maintain it weighbridge, or it can settle it with a private party. In case it settles with a private party, my lord, it is categorically provided in Rule 3 of the said rules. It has to be done through tender, your lordships. Now, my lord, thereafter comes, my lord, how the permission is to be accorded. Now, my lord, in the rule, only two authorities has been spelled out. One is, my lord, secretary, which of course will include, my lord, secretary and commissioner of transport. And other is, my lord, the commissioner of transport. These are the two authorities only named. Now, so far the commissioner, my lord, of transport is concerned, your lordships, he will find there are certain conditions, my lord, for granting permission. Whatever by name your lordship calls it, license, permission, permit, whatever it may be. Now, how it is to be obtained, your lordship? There are certain requirements. On fulfillment of these requirements, my lord, permission is accorded.
Okay, we just come find that the rules are there. Number 2 is that you were running it from, which was the first 3 years?
17
to 20.
17 to 20.
And 20, it was again renewed for 3 years.
20, what happened, your lordship? 20, actually, it was exact date of expiry was, my lord, 5th December 2020. Now, because of the situation prevailing here, what happened, my lord, government had issued not a renewal, an extension, my lord, for time being, an extension for time being, on the condition that the 50% of the pending dues would be paid, your lordships. Now, thereafter, what happened, my lord? After this formal extension, my lord, this by implication, this continued. I was continuously, my lord, operating the weighbridge on payment. Now, so far this part is concerned, my lord, that I was continuing during this period, your lordships. That statement has not been, my lord, controverted, my lord. I'll come to that. That was not controverted in the affidavits. They have admitted, your lordship.
So, you ran 17 to 20. Correct.
20. Thereafter, I continued on the basis, initially on the basis of the extension order.
Yes.
Initially on the basis of the extension order.
Yes.
Thereafter, I was allowed to continue to run it, my lord, on payments. Payments were regularly made, your lordships. And these facts I have stated
so
in
2017 was by tender.
Tender. Well, that is, they have admitted. They have admitted.
No, okay,
fine.
That now 2020, after you're allowed to run it just like that, ad hoc.
Well, just.
Then after 2020.
Now, my lord, in the meantime, what happened, lordship? There is a development because.
So by payment of 50%.
50%, my lord. I'll come to it. Now, what happened here?
Just let me get the
lordship.
Then by payment of 50%. Okay.
Lordship.
Then you ran this kind of arrangement carried on till.
Till, my lord, again it was renewed.
Till when?
Till when, my lord, I'm coming here. Here what happened, your lordships, in 21, when I was still running, my lord, on this basis, I filed a writ petition. The reason for filing the writ petition, because as per the agreement, as per the rules, my lord, before the expiry of the, my lord, original license, the leasee is required to file an application along with other requisite documents for renewal. That was pending. They had not taken any decision on that.
But meanwhile, you're still running the gate.
Yes. So I filed a writ petition, and that writ petition was ultimately decided, my lord, in sometime in the month of May
2021.
2022.
Okay.
2022.
So you ran it from 2020 to 22, right? Okay.
Lordship. Now, my lord, there, my lord, promised us there. Now, there the government, my lord, filed an affidavit.
Yes, that we are.
No, my lord, will take note of that.
Last time.
No, my lord, that affidavit, my lord, that affidavit on behalf of respondent number 2 and 3 in that writ petition. Now, respondent number 2 is the secretary, secretary of the transport department, and 3 was the, my lord, commissioner of transport. And they collectively made a statement in paragraph 5.
Yes.
Paragraph 5, they collectively made a statement. If I can take my lord to that, that is important, your lordships. Lordship, it starts this affidavit I have annexed at Annexure 7, page 45. Page 45, my lord. If I can take my lord to page 46, paragraph 1, your lordship. I have been, sorry, my lord, Commissioner on Transport was respondent number 5 in the instant writ petition, and I have served a copy. I have read, understood, and I am swearing, last line, this affidavit on my behalf and on behalf of respondent number 2. This respondent number 2 is secretary, commissioner and secretary of the transport department. Now, my lord, lordship will kindly come to page paragraph 5. The statement made in para 8 are correct, and with regard to the mention about the provision of the rule, and the petitioner is advised to approach the Transport Department for favorable renewal. Lordship will see the language, which will be considered taking in view the provision of Rule 7. They are referring to that Weybridge rules, which contemplates my renewal. Meghalaya Installation, Regulation, Maintenance of Weybridge 2009. And point 2, clause 3 of the Meghalaya State Policy of Weybridge 2018. And after proper scrutiny of records documented related to the payment of all government dues. In fact, it is also stated that recently the government has accepted petition for extension of lease agreement in respect of Majai Weybridge, East Khasi Hills districts. Now, my lord, here they have committed, your lordships, that what are the criteria they will look into for the purpose of renewal. Now, they have said we will take into consideration the rules of Rule 7 of the Weybridge Rule of 2009, and other thing your lordship also will take note, my lord. Point 2, clause 3 of the Meghalaya State Policy of Weybridge 2018. Now, my lord, here I need to clarify, your lordship. Point, they have mentioned point 2, it should be paragraph 2. Point 2, clause 3 of the Meghalaya State Policy of Weybridge. The same paragraph, my lord, paragraph 5.
Okay.
Page 46.
Yes.
So they are referring to the rules now as well as to the policy. Now, my lord.
Yes.
Government of Meghalaya also, my lord, formulated a policy for settlement of Weybridge, my lord, settling, operation and settlement of the Weybridge also. Now, obviously, my lord, these are, my lord, to supplement the rules. That speaks about the procedure, how it is to be done. Now, my lord, they have made the commitments, and thereafter, your lordship, next page, my lord, next annexure 8, page 50, my lord. There were, my lord, 3 writ petitions, my lord, involving similar issues were taken up together. And your lordship, by order dated 9/5/2022, disposed of the matter, my lord. This is a short order, your lordship. Page 50, annexure 8. Now, my lord, paragraph 2, it appears that the petitioner are still running the Weybridge. There, your lordship has mentioned that running the Weybridge, and as per the affidavit of the state respondent as indicated in paragraph 5, the renewal of the petitioner license will be considered in the event then an appropriate application is submitted before the state respondent. In view of the circumstances and affidavit placed, Mr. Such and such another single counsel the petitioner submits that the writ petition can be closed. Accordingly, it is directed that the writ petitioners to approach the state respondent with an application within a week, which is considered expeditiously, preferably within a period of 1 month from the date of the receipt of the application, with the direction placed. So, lordship, here, my lord, lordship has issued certain directions, my lord. One thing, your lordship has directed to file an application, formal applications. That was a direction came from the court. Now, next, the case will be considered. Lordship has not said settle it. Obviously not, your lordship. And the other is expeditiously, preferably, my lord, has set a time of 1 month from the date of receipts.
Yes.
Now, thereafter, your lordship will come annexure 9. Well, I'll read out. This is not a very long order. 30th May 2022 orders. The Honorable High Court of Meghalaya, while passing judgment in such and such in these 3 writ petitions, my lord, has directed the petitioner to approach the state respondent, that is the Transport Department, with an appropriate application within a week, which is to be considered expeditiously, preferably within a period of 1 month from the date of receipt of the certified copy of the order. The Office of the Commissioner Transport Shillong thereafter received the copy from the petitioner on 11/5/2022, which has been processed. Lordship will take note of this thing, processed and forwarded in original to the Transport Department. It has gone to the department, my lord. Now, they have given the reference number of this thing because a number of Weybridges were involved. Therefore, in order to comply with the direction contained in the Honorable High Court order, petitioner is hereby directed to pay a renewal fees of 250 by Treasury Chalan, positively by so as to ensure enable signing the agreement in respect of such and such these 3 Weybridges. Now, here the confusion, your lordship asked me, that court has never given directions, my lord. Now, this order no way reflects, your lordship, that there was a direction to settle the weighbridge and they have settled the weighbridge only because of the order of the court. That is not correct, my humble submission will be.
No, see, they have to comply direction contained all High Court order. The person hereby directed to pay the renewal fee.
Exactly, my lord.
That means accepted,
number one.
Accepted in toto without any consideration.
What I am saying, my lord. No, what is
okay, it doesn't matter. You can
what is renewal fees?
Yes.
Because lordship has asked, this renewal fee was paid much before, my lord, the expiry of the original license. Now, lordship has directed file an application. No, obviously, but anyway, that payment of 250, my lord, that will not vitiate the thing. That should not, my lord. I don't think that will be so fatal. So only reason 250 was asked perhaps because lordship has directed file an applications, because when the application was already pending. So, my lord, my humble submission here will be, your lordships. Here, my lord, it's not the case that settlement has been made only because of the order. Because they have categorically spelled out what are the criteria they will look into in paragraph 5. And lordship has taken note of that paragraph 5. And thereafter they processed, it has gone to the department, it has the requisite approval. And then ultimately, my lord, the agreement has been made. Now, your lordship will kindly come to page 55, annexure 11. Now, my lord, this is the agreement executed on 1st day of June 2022. No, sure.
Yes.
My lord, the relevant, my lord, the period of extension lordship will kindly come at page 58.
Yes.
My lord. Now, therefore, the agreement witnessed as under. The license take effect from 1st June 2022 and shall remain valid for a period of 3 years from the date of commencement. The agreement shall stand concluded on 31st May 2025 by effects of time. No matter here, your lordship will take note because they have argued in their petitions, pointed out certain things. Here, the my lord, least subject, my lord, is license. Permission. Somewhere, because that will come.
We have to take into account also one thing, Mr. Sen, is that the proper settlement by tender was done as far back 2017.
True.
And then 20, we are up to run it, it came 21 to court. So, in effect, from 17 to 23, you've run the thing for 6 years. It'll come to around 6 years. Yes. Yes, continue. It's just to remind myself. Yes.
Lordship. No, my lord, that 6 years I have calculated. Even that 6 years, if your lordship counts, that 6 years expires, my lord, in December, of course, December 23.
7/12/2017.
7/12.
It was the first lease year.
Yeah. Even if your lordship count that period should have been taken into consideration.
So you can extend it till 7/12/2023 then?
2023. Yes. Now, my lord, the least subject is permission, because they are saying, my lord, they are referring to certain under decision and all. I'm just, that will come. The subject itself is permission. So this agreement deals with permission. So this permission has been granted, my lord, for 3 years. Following the rule, apparently, my lord, this is following the rules contained in the weighbridge rules. Now, your lordship will, I'll take my lord. Thereafter, I have been running, my lord, on payment of the whatever the requisite dues are there. Then, my lord, this is the one. This is not this one. 6/7 July. I can take my lord to 76. Annexure 13.
76.
My lord. Annexure 13. Renewal of license. You are hereby informed that the agreement for operation of weighbridge at Amsarin is extended up to 39/2023 as conveyed by the government in their letter number dated. This is an internal communication, I do not know, my lord, first time, my lord, and this has been done in spite of the fact there is a subsisting contract. there is a subsisting contract, your lordships, which categorically say it would expire only on 31st May 2025. Now, this has been issued, my lord, a decision has been taken, my lord, without involving me anyway, your lordship. I have not been even in a shock cause. I have not been given any opportunity of hearing, my lords.
Yes.
Now, my lord is aware, any question of any license, however granted, my lord, if it is sought to be withdrawn earlier than the durations, my lord, but can it be permitted, my lord, without affording an opportunity? This is a gross illegality, my lords.
Yes.
Now, my lord, will come next. In fact, my lord, I approached them already. I said it could not be because I was initially under the impression, my lord.
So, for the 1 year, your renewal is over. So, for next installment, you have to pay for this consequent period now.
Two more installments, my lord.
Okay.
23-24. Now, so for 23-24 concern, your lordships, my lord, I was under the impression, my lord, there was some bona fide mistake on their part. Already I approached them, tried to impress upon them also, your lordship. Then what I did by Annexure 15, my lord, 1st August 2023.
Yes.
Now, my lord, I'm not 1st August, my lord. 1st August, when I, my lord, submitted the challan, I got this reply, 1st August 2023, which say, my lord, with reference to the subject cited above, I am to return here with the original copy of the challans for the second and third installment of the annual fees for the year 2023-24, as the government has conveyed its approval for extension of the agreement only up to 39-2023.
Okay. So now you said, firstly, you not heard before this letters were issued. No. Second point,
my lord, this has been, my lord, done, your lordships, because that period, my lord, from the lapse from after the expiry of the, my lord, first license is formally extended. I will just take your lordship to that letter also. Formally extended up to 31st December 2020. Thereafter, my lord, I was allowed to run on payments.
We can
50%, your lordship. So I continued to run, my lord, that periods. The renewal never came. I filed an application. When I filed an application, your lordship, they came before the court, make a categorical statement that these are the criteria on the basis of which we'll look into it, and we have done
fine.
it.
That is over. They looked to it and they renewed it for 3 years.
Lordship.
By saying the order of the court said renew, so in compliance.
Lordship.
As per the, we're not saying that
by
rightly or wrongly, it was renewed.
It was renewed, my lord, and they have renewed looking into the records. Now, that I'll need to comment to your lordships. Now, how the renewal is to be done? Now, that is something, there is something not provided in the rules. Now, rules are supplemented by a policy decision. Now, I have annexed, I have brought this by an additional, my lord, affidavit in reply to their.
Okay. Where is that?
My lord, if your lordship take up my affidavit in reply, dated, my lord, 29-23.
Where is it annexed?
Lordship has got it.
Yes.
The my lord, type copy of the policy decision starts from paragraph page 19.
19. Okay.
19, my lord. This is dated 1st November 2018. Now, my lord, if I can, your lordship, because one of the questions they asked, my lord, he is not the competent authority. Now, my lord, policy decision has spelled out very categorically.
See, how does this policy supplement the rules?
No, it's not. I'm not saying, my lord. What I'm saying, my lord, this policy decision, my lord, cannot substitute the rules. It can only supplement, my lord. Only where the procedures are not provided, they provide the procedures. So this is in any case not in conflict with the rules, your lordship. Now, why
are you showing this Meghalaya state policy then?
State policy, my lord, this state policy has been formulated, my lord, to supplement, my lord, where the procedures are not provided in the rules.
Now, are you trying to say that your renewal was based on the policy?
Not only policy. Policy is there. I mean, rules are there. Rules say it speaks about renewal. Now, these further say if normally it should be given. Normally it should be given, my lord. I'll just take my lord to that particular paragraph.
Yes.
That is at page 20. Sorry, my lord. Page 23.
Yes, installation.
Enforcement of weighbridge rules. The government of Meghalaya in Transport Department shall ensure that all weighbridges are governed by in the weighbridge rules, and the weighbridge operators abide by the said rules and also strictly adhere to the terms and conditions as laid down in the lease agreement. The lease contract shall be for initial period of 3 years, which can be renewed on fulfillment of the requirement as per the agreement. Now, as per the agreement, my lord, the payments. The licensee shall pay to the government the agreed lease amount in 3 monthly installments in the 7th day of every month following day if the 7th day falls on a holiday. So, my lord, if your lordship look into the agreement, my lord, the payment on installment.
What does the rule say about renewal?
Regarding renewal. Regarding renewal. My lord, I will take it.
Page 26.
Of
the writ petition.
Rejoinder?
No, my lord, writ petition. Lordship will kindly come to the writ petition, my lord. You start from page 25. Start from 25, your lordships.
Yeah.
My lord, so far the renewal is concerned, my lord, renewal for permission, your lordships, at Rule 7, page 26.
Yes.
Any permission referred to in Rule 6 above shall be renewable every 3 years, and on no such permission shall be granted or renewal unless the proposal for grant of or renewal of permission, as the case may be, is accompanied by the certificate issued by the Inspector of Weights and Measures, Government of Meghalaya, as to the accuracy, correctness of the device. So this is renewable for 3 years, my lord. This
permission.
Permission.
Permission only. Permission means that.
Permission means, my lord,
having your own independent way bridge, do you have to go for permission?
No, my lord. I'll just clarify this. Now, my lord, if I can take my lord, permission is
for settlement. It's for permission.
For permission, my lord. That's what I'm saying. If I can take my lord to the page 25, my lord.
Okay.
This speaks about permission. Rule 4.
Okay.
Rule 4.
Yes, read.
I just read it. No way bridge without permission.
Right.
My lord.
No. Yes.
No, sure.
Right.
Shall I read it, man?
Yes.
Private person, body person, company, organization shall not be eligible for obtaining lease permission to run weighbridge unless he has attained the age of 20 years above and he has made an application for grant in writing, etc. Now, these are the requirements. He should be a major. All these things, the requirements are there.
No, see, what this court is trying to understand is this: whether it's a general permission. Suppose I have my own private weighbridge, I'll have to go through this process also.
Without permission, cannot be operated at all.
I mean, private weighbridge also.
Even private.
It's not that I'm opting for a lease with the government to run weighbridge on behalf of the government. The only thing is that now, suppose I have there's somewhere I want to install a weighbridge. It has
for private purposes.
Yes.
For private purposes, it may not be. This is for commercial purposes. For the
private means private purposes. It means like you see in everywhere. Before you enter a stockyard, something. These people have their own private weighbridges, so they'll know how much weight, how much goods are coming in. Now, for those kind of weighbridges, do you need permission or not?
It will be required. All will be required.
So it's a general permission. It's not a question for permission for for what do you call it? Not like a license by the government to operate on their behalf. Correct?
Lordship.
It's different. Permission and license is different.
Permission and license are different. Okay. In fact, my learned friend has referred to Kaminlang Suyam. That question came up big way.
Okay.
That lease subject general terms and conditions are not same as permission. Permission is separated, subject to the rules.
Also, permission then renewal.
Exactly.
If you are complying with you're running your private weighbridge, you will get renewal automatically.
Right.
But does that mean that license will be renewed automatically? That means it won't cut both ways.
Lordship.
That means permission is fine. If you take it for granted, you give your
but then here might not
50 rupees, right? Renewal, you can run a weighbridge. But does that mean that your lease with the government will be renewed automatically? These rules do not cover that. As per what it shows, yes.
No, I'll take to the original first agreement. Then that will clarify things, Your Lordship. No.
Okay.
Now there cannot be. I cannot operate a weighbridge, my lord, without permission.
Of course.
Without permissions.
Of course.
Now then
that's a basic basic requirement. Okay. If you have permission, then you're eligible to ask to tender it when there's a request for bids. Then since you have a weighbridge that already has got permission,
so for these weighbridges, so for these my weighbridge is concerned, Your Lordship, it's not that right from 2000 before then NIT was invited, I was having it in place. I was not having it. What was the NIT? NIT was floated, my lord, with the private parties interested to set up weighbridge for the purpose to be used by the government. Now specifications were there. I submitted my bid. I was selected. Thereafter, as per the government specification, I made the construction.
Okay.
I made the construction. So once I made the construction, what they did, my lord? Permission is required. Now both permission and general terms and conditions, my lord, this was combined into a single agreement.
License.
For general license as well as general terms and conditions.
Okay.
Now I'll take my lord to Camelong, so that was a little different. So both were combined together. So when it was renewed, my lord, general terms and condition was renewed, license, whatever name your lordship, this also means permit, that too was renewed.
Okay.
Now, my lord, Rule 5.
Yes.
Permission for weighbridge at the satisfaction of Commissioner of Transport. In considering the grant of permission, the Commissioner of Transport should satisfy himself that the proposed place for installing the operation of the weighbridge in the National Highway PW shall fulfill the following. These were the requirements to be fulfilled, my lord, to the satisfaction of Commissioner on Taxes, Commissioner of Transport. Now 6, Commissioner of Transport to forward the application to the Secretary Transport Department.
This all concerns permission. Now come to the licensing part.
My lord, here the licensing, my lord, what would the license is the permit. This is the permission. License is the permission. My lord, what is the meaning, my lord? Otherwise, going by the dictionary meaning of license. Permit. They are called permit, permission, license, whatever name your lordship for.
Well, let's see your first agreement. What is it?
Yes, first agreement they have clearly indicated.
What are these?
Yes, my lord. First agreement is page 35. Page 34, my lord.
I think it has to come from the code that it should be two different things, permission and license.
Lordship. But they have combined both here. I'll just try to show you, Lordship. Lordship, if I can read, my lord, from page 34, my lord, last paragraph. And whereas the government had, by giving public notice, there 10 invited application from interested parties for setting up weighbridge and Ramsari Road for the purpose of winning motor vehicles, etc., etc. And whereas the licensee has, besides other submitted application, government and the licensee was given permission to set up weighbridge at Amsarim Juwai Dauki Road.
Yes.
And whereas on completion of the construction installation of the said weighbridge, the government hereby enters into an agreement with the licensee on 7th December 2017 for utilizing the said weighbridge for the purpose of weighing good transport vehicle to deter overloading and for collection of fee, etc. on payment of government approved amount of such and such.
Fine. License you can, it'd be like a grant of agency, you can say.
No, my humble submission will be here so far, in what context they are using it. Because they have referred to Rule 7. I'll come to that, in the agreement they said, when it comes to renewal of license, they will go by 7. Lordship will come to next page, my lord. Next page 36, that's clarify everything. The license shall remain valid for 3 years, which is in accordance with the provision of Rule 7. My lord, there should not be scope of any doubt here.
It's absolutely confusing. Because the way the agreement is crafted is absolutely confusing. The person who wrote the recital doesn't have a flying clue what he's writing also.
They should have used the word permission, I understand.
No, I know, it is, what does the rule say? What is he writing the agreement? This is totally, it's like a contrived agreement.
So, my lord, yes, exactly.
Very sorry.
They should have said the permission. They should have said permission is a license. Now, this license here, that's why, my lord, it's not just in the year I am making the submission. I am relying on their documents. They themselves are saying license is the permission.
Right. You have every right. You have every right to rely on the document they've given you.
But I understand they should have used the correct words. Yes. They have created the confusion. So here, all throughout, they are using the word license as permit or permission, and this is governed by 7. So there is no doubt, my lord, everything comes from the statutes and backed up by the policy decision.
Okay.
My lord. So here the license means, my lord, the permission under the rules. Now, my lord, if I can, my lord, because one of the contention they raised in their affidavit and all, they have said, my lord, they have referred to a decision, my lord, almost on similar kind of issue, my lord. The facts were different. There also came the question exactly what lordship is asking. Exactly. Lease subject, general terms and condition is one thing. Permission different. And there, of course, the agreements were made only on general terms and conditions. So there was a provision for renewal of the agreement. Renewal was applied, then the government said, where is the permission? So they applied for permission also. So permission was rejected. When the permission was rejected, the court said, once the permission is rejected, there is no question of renewal of your agreement. Right. So they have covered that aspect. But here is the case, my lord will try to appreciate. Here, my lord, both they have combined into the single agreement.
Yes. Yes.
Now if I can take my lord again, because he is questioning who is the commissioner, how he should have lordship.
Who's questioning?
My lord, their affidavit, they are saying, my lord, they have raised three contentious issues.
That means that the renewal is a sovereign action of the commissioner without any consonance from
Exactly, my lord. How can it be, my lord? Without approval, it can't be. Because I have seen the commissioner in his letter, he said he forwarded two things have come. And what the policy decision say on this, my lord? Policy decision has spelled out. Because who will sign the agreement, my lord?
The agreement expires on?
30th.
That is Monday.
Monday or Saturday?
That is on Saturday.
Saturday, my lord.
Yes.
Saturday. Just if I can read, my lord, that policy decision. This throws light on this thing, but how it will be executed or not. Typed copy, my lord, start from page 19.
Yes.
Lordship. Not my few paragraphs, my lord. I'll just, if your lordship bear with me, my lord, this is very important, reflects many things.
Yes.
Now, first is the background. Background, they are talking about the executive instruction. 2003, no rules. Executive instruction was holding field. 2009, rules has come. So, my lord, that we can skip perhaps. No, my lord. If we can start from the last subparagraph in this page 19 only. In Meghalaya, the weighbridges are operated by private parties on payment of annual lease as agreed between the government and operators. The Commissioner of Transport floats tender for all weighbridges, and the comparative statement along with the tender papers are sent to the government for selection from amongst the bidders. Commissioner of Transport then sign
that is very important. Floats a tender.
Lordship.
You see, floats a tender.
Fine.
Yes. Carry on. Yes.
That is there, my lord. Approval has to be there, my lord. It is there.
No, it's a process. I mean, it's a tender.
It's a process. It's a process.
Yes.
The Commissioner of Transport then signed the lease agreement. Now again, my lord, he is the one who signed the lease agreements. Lease agreement with successful bidder, tenderer to operate the weighbridge. The successful bidder tenderer will have to sign and furnish an inventory. A clearance certificate from the concerned inspector of legal metrology will have to be obtained by the licensee before the commencement of the weighbridge to ensure that the weighbridge apparatus conforms to the standards required for the purpose. The agreement is being executed after the licensee has made security deposit of 15% total bid amount in favor of the Commissioner of Transport. The security amount will be released only after satisfactory completion of the contract. The licensee thus signed the lease agreement with the Transport Department, thereby making contract and agreeing to the terms and conditions for payment of all government dues and to continue the operation and function of the revised charges, fees, etc., etc. Now, my lord, here very clear and categorically who does it, because it is not spelled out in the rules that only the commissioner will do or secretary will do. The policy decision, my lord, this is what supplemented the rules.
So the commissioner is a competent authority.
Yes, exactly.
Okay, you say a policy says the commissioner is the competent authority. Okay.
Now, my lord, the other thing at page 22, if I can take your lordship, they have raised in there, my lord, they have relied in a, my lord, decision of Kamenlang Swan. The situation was totally different.
What is it saying that this is?
They are saying that, my lord, the government policy was that settlement, permission, etc. should not come from the head of the department. It should be on the recommendation of the state government. That position do not exist. This has been altered by this policy decision of the government, my lord. If I can take my lord to
okay, continue. Yes.
Page 22.
Yes. Let's finish your part fast. Yes.
Page 22, my lord.
Yes.
1. 2, under my lord, state policy of weighbridge, point number 1.
Yes.
The nodal department for granting permission.
Yes.
The Transport Department is the nodal department for issuing permission for installation, regulation, maintenance, operation of weighbridge in state No department shall install or operate any bridge without the permission of the Transport Department. All deputy commissioners are empowered to close all unauthorized bridges, checkpoints that may have been set up without the express approval government in Transport Department. My lord, there is no iota of doubt, your lordships, now that it is only the Transport Department which is the competent authority to issue. And secondly, my lord, we will look into it. Even if there is some other policies, my lord, say something otherwise, this will run counter to the rules. Statutory rules, my lord, only two authorities are mentioned. One is Commissioner of Transport, other is Secretary Transports. They nowhere say, my lord, a recommendation from the state governments. So, my lord, so far, otherwise,
the very fact that renewal is given to you on 30th of May 2022, correct?
No, sure.
Yes. The very fact they allowed you to run, that shows that they cannot set up the ground that the person who, under whose signature renewal was given,
no, sure.
They cannot say that, turn back now and say that, you know, that you're not competent. That argument will not hold any water.
Firstly, my lord, another thing.
That also the court will reject.
My lord, I could satisfy your lordship. And even the first agreement. First agreement, so Commissioner of Transport.
See Rule 6, your lordship. Rule 6 has not been pointed out.
I'm pointing out.
Rule 6.
I'm saying again and again, your lordships, that I will not skip anything, your lordship. What is the procedure? It has to be, Commissioner and Transport will have to satisfy that a person applying for permission fulfill all the conditions. Thereafter, he process.
What you're submitting is that when the time of renewal, the Commissioner of Transport had done the due process.
Exactly. No, what my learned friend is saying, I have skipped 6. I will not do that, my lord. Why I should? What it say, my lord? Once the Commissioner of Transport is satisfied that all conditions are fulfilled, he will place it before the Secretary. He'll place it before the Secretary for permission. So obviously it comes with his approval, right? As regarding renewal, my lord, they are not saying in so many words who it is. But obviously normally it follows, my lord, the person who is granting, he should renew it, my lord. Now my lord, here is a case.
Just Process Act.
No, here, my lord, what I am saying, the order of the Commissioner before he made the renewal categorically stated this was processed, sent to the department. If their case is this, Secretary has not approved. Secretary was before this court along with the Commissioner and Commissioner of Transport, and he made a collective statement. Yes, we are going to do it on these criteria. Files were processed, sent to him.
No, okay, leave that aside.
And then I'll place a letter also, my lord. Now, my lord, now there is no dispute, my lord. This is, since your lordship already, my lord, taken some kind of view. And even the first agreement is between Commissioner of Transport and me. Now, my lord, in their affidavit, your lordships, the first issue they raised, of course, my lord, I'll say, because initially when lordship take it up for motion, there was some reaction. Of course, the writ kit can always make a searching inquiry, whether it is there in the impugn order or not. Court can always ask how it is done, my lord. There is nothing wrong, my lord. Lordship has that power. But, my lord, they have taken the cue only from that. And they are saying, my lord, I am so casually done. They are saying I have misrepresented. How I could have misrepresented, my lord, I could not understand. They are repeating that I have misrepresented and obtained disorders. My lord, that is something unfortunate, your lordships. Now, government coming up with this kind of affidavit, your lordships. Now, if I can take, my lord.
No, what he's saying is that, number one, misconstrued the court order and renewed the permission, renewed your whatever your permission, whatever, to run the your agency, you can say.
No, sure.
I won't say license or permission. No, sure. Without going through the rules, without abiding by the rules. That I think some substance is there.
That I need to clarify.
That's the only, that's yes. So clarify the second part. Other part, natural justice is different. Now, but then you come to other part, like, you know, this is a commercial transaction. Correct. And if it's a commercial transaction where you're seeking a sort of performance of, you know, implement of the agreement. Now that is a different footing altogether. The only thing, the discretionary power that the court will exercise with regard to the manner in which the decision-making process was done before it came to the impugned letter, which he said he had no knowledge of. See, we tried, the court tried to limit it to that only. But if it's a commercial transaction, then That is...
Yes, man. They have raised. I will have to answer that also. They have raised. This is a commercial transaction. You know. Then I will come, my lord, statutory incorporation. Now, what is statutory incorporations, my lord? If statutory incorporation, it is just not a
you say
clause.
Statutory contract, that's why writ will lie.
No.
So,
that I'll
it's a statutory contract, right? You say, but then their stand is that is not as per the rules.
No. What I'll say, my lord, I'll say maybe entire contract. Now, what the law say on this, your lordship? Law say the entire contract may not be a statutory contract. Some clause of it may be statutory. Now here, my lord, we are concerned only with, not with the general terms and conditions, because he has last time complained. See, the original lease amount that has not been revised. I am not going into that. They have mutually agreed and they kept it as it was before. Now we are concerned only with, my lord, whatever name you call it, license, permission, whatever it may be. Now by their own admission, this is governed by Rule 7. And whatever they have incorporated, my lord, obviously following that rules, otherwise they cannot do it. Policy decision categorically say that weighbridge cannot be operated without following the rules. So that is a statutory incorporation. If it is a statutory incorporation, it is just not merely a clause of the agreement. It gives right to a statutory rights.
But once it is a interpretation again, Mr. Sen, with regard to how they've used that, that whether that rules applicable at all in the circumstances of your case.
Lordship, that rules will come, my lord. They have, without this rule, see, Lordship will see the sequence of event. Initial tender.
It's a full day hearing. Only sorry that your 30th is the last date.
My lord.
So we'll pass a short order.
Whatever you do, your lordship says.
Yes, you try to complete this.
Lordship. Now, my lord, Lordship will see the sequence of event. This tender under the rules, then the settlements were made, the renewal, whatever name they call it, license or whatever it may be, they themselves are admitting to be guided by 7. When I filed the case, they have come before the court, secretary and commissioner and secretary is saying this will be as per Rule 7. Will my lord doubt, should your lordship have any doubt that this is not a statutory incorporation, it is otherwise? When they are admitting everything on record, my humble submission, my lord, this is a statutory incorporation, nothing else. It has to be.
Okay.
Now, my lord, coming back, your lordships, my lord, misrepresentation. I don't know how it is misrepresentation, my lord. This is something, my lord, a very casual submission, my humble submission.
Is still the same commissioner secretary now also? Commissioner, same person?
Secretary is...
No, the same person, commissioner transport now also?
No, we have removed him.
You have not taken action against him?
We have removed him, transferred him.
No, there is a lot of difference between removed and transfer. Removed and transfer.
That I know.
Should not be used like this so casually. Remove means you have punished him, he did something
because
wrong.
The order of renewal is...
needs some...
absolutely,
my lord,
offensive.
No, my lord, I just...
No, we'll not go there. We'll not go there. They have renewed. That's the baby. But I'm saying, yes.
Lordship. Now, they cannot say that they have made an agreement. They say otherwise, if they had said, no, there was a scam. We have ordered an inquiry, my lord, ED has come, all these things happened, understandable. Now, what they don't find your lordship suddenly, they say no extension. They are not saying it is bad. Without any reason, they are saying no extension is only up to 30th September. No, what justification? Without affording me an opportunity.
Yes.
Now, my lord, misrepresentation, my lord, this is something, a very casual statement. Now, my lord.
Now, what you talk about one judgment was that Kamelang Suyam?
I'll come to my lord, Kamelang Suyam. That is, your lordship, a decision reported in 2011 SSC online.
So they've given...
Which your lordship I have given it. It's part of the compilation. First judgment, Lord.
Okay.
SSC online, Guwahati 86. My lord.
Yes.
Lordship has got it. Now, my lord, I'll take your lordship to paragraph 26, 27, 28.
So now they're taking a stand that your permissions have been renewed.
Lordship.
Are taking a stand the permissions have been renewed.
My lord, there are two things. They are, my lord, because otherwise the long judgments, my lord. Transport Department made an agreement with certain private parties to use their weapons, and the agreement contained only general terms and conditions. What is the money, how it is to be paid, nothing about permission. And it also contained a, my lord, renewal clause. It said that after expiry, if an application filed within renewal fees, then renewal will be considered. Now, these people, what happened here, my lord, after the expiry, they filed a renewal application. That was, my lord, and they also filed, my lord, they were told that without permission you cannot. They separately filed a application for permission also, separately, not in this agreement. Now there what happened, that permission was also rejected. Now that was challenged before the court. Then the court, my lord, held that these agreements are, my lord, containing general terms and conditions.
So the whole thing, Mr. Arvind, the whole thing is that what the state has done is mixed up this permission, mixed up this lease, and mixed up the license, and mixed up everything.
No, Your Lordship,
now,
what is being...
if you swing by the rules, that means it's only question of permission. It can be A, B, C, D, Weybridge.
No, Your Lordship,
right?
I will show the facts.
And then you can't wed it together,
what is being said, my lord, what is being said and shown is not correct. If I will show the facts...
It's very correct what he said.
I will show the facts.
If we go by the agreement, which is,
No, I will show how it has Rule 6, Rule 7, Rule 4 and Rule 5, my lord. These are the 4 rules and how the decisions have been taken, my lord. And Your Lordship will see the wordings also. I'll just...
Yes, definitely. Now, my lord, permission was refused, so that was challenged. So the court, they are discussing, they say the agreement was for general terms and conditions, right? So this is always subject to the rules or the executive instruction holding the field in 2003, which a permission has to be obtained, my lord. So my case here is different in the sense, my lord, both has been combined together here, your lordships, in the single covenant, single agreement, general terms and condition, as well as the license, permission, whatever, your lordship, they have used the word license, my lord, that is by way of, my lord, statutory incorporation. This is admittedly, my lord, in exercise of the power, Rule 7. If I can take my lord to (24) and 33, your lordship, paragraph 24. My lord, sorry, your lordship, if I can take my lord to 26 and 27.
Yes.
What is, however, paramount importance to note is that unless permission was granted under the executive instruction, that is in 2003, my lord, aforementioned, or granted under 2009 rules such and such, the question of weighbridge being installed or operated by party does not arise at all. Granting permission of weighbridges and consequently a lease cannot be granted unless permission is granted, or a lease cannot be renewed unless a permission itself is renewed. Well, here I will pose again, your lordship. Here in the single agreement, again, I'll see, even the renewal, my lord, this has been incorporated in the agreement. Now 27.
Exactly, that is what this court is observing.
They could have done it separately, my lord. It's their job, my lord. For that, I should not be made a scapegoat, your lordship.
Was it a mess made deliberately?
I should not be made a scapegoat. I am a layman, your lordship. I am a businessman. I am not supposed to understand all those things. But admittedly, they have combined together into a single petition, a single agreement.
I think we'll do one thing. This matter needs a proper judgment.
Exactly, your lordship.
Lordship can streamline.
Yes, your lordship. I wanted judgment on this point, my lord. If my friend has finished, he has taken almost 1 year.
But how the state has been running these weighbridges, like by mixing up this whole thing into one.
If your lordship give me only 5 minutes. Only 5 minutes.
Being clear on, like, there has to be clear parameters.
Only 5 minutes.
Permission is different, license different, lease is different. Are you making agency?
Kindly see the rules, my lord. Kindly see the rules. Only 5 minutes.
Small suggestion.
Only for rules.
My lord, lordship need to streamline, my lord, all these things. I am a landman, see my condition. What is my fault, your lordship?
Your fault I will show just now.
What is my
fault? I will show your fault just now. What is your fault? Kindly see the rules, my lord. Rules, my friend has not read Rule 6, despite he has no reason to. There are two, this structure of granting, without referring to the rule also, my lord, there is a structure. There is a directorate which is headed by Commissioner of Transport, and there is a government who is represented by Secretary, my lord. Now, Rule 6, my lord, if your lordship will see page rules, which page the rule is there, and page 26, your lordship will kindly come to Rule 3 first. The government may install and maintain by itself as many weighbridges for the purpose of section 144 of the Act on such places as it may think necessary, or may allow any private body or person's company or organization to install and maintain such weighbridges on payment of lease amount to determine in each case by the government after calling tender. No, provided that no lease shall be granted permission to any private person, body or persons, company or organization unless fulfilling the criteria laid down in 4, 5 and 6, my lord. 4 and of these rules. Now, your lordship, most important, 4 and 5 have been read. 6 has not been read to your lordship. 6 has not. 6 has not been, I can show on YouTube also that 6 has not been read. 6 has been suppressed.
Show on YouTube.
The recording, my friend has not read it. He has read 7, he has read 4, he has read 5, but he has not.
Submissions. I made a submission that should come from the secretary.
When he was reading, my lord, 4 and 5, it was his duty to place rule 6 also, my lord. That is what lawyer's job is. Lawyer's job is to present his case. 6. Commissioner of Transport to forward the application, my lord. Kindly see 6. Yeah. Commissioner of Transport to forward the application to the Secretary Transport Department. After satisfying himself that the application is complete and meets the requirement as laid down in above said rule 4 and 5, Commissioner of Transport shall forward the application with all required information to Secretary of Transport Department for issue of permission. So government will go to the government for permission. After permission is granted, my lord, then the lease will be executed. This is what happened in 2017 and this has not happened in 22. There is no permission, my lord. Without permission, Commissioner Transport has executed the agreement. And if I can show your lordship the letter of
why is not speaking? Then why is your impugn or doesn't speak?
No, your lordship,
that the renewal which is granted agreement signed was on the basis.
I'll answer that straight away. I will answer that.
In the sense that
Yeah, I will answer that straight away, my lord. The issue is that, my lord, permission. If your lordship will see the term of the previous 2017 agreement and 22 agreement. 22 agreement to 17 agreement clearly says that government has granted permission. 22 agreement, my lord, does not say the government has granted the permission. The wordings are missing. Wordings are not identical. Wordings are not identical. So without permission, my lord, the issue which falls for lordship's kind consideration is one, my lord. There is a statutory rules which says that in this manner the permission has to be or license has to be executed, my lord. The manner is that all requirements are to be satisfied by the person, tender, etc. and then thereafter it will go to the government for permission. After permission, after rule 6, rule 7 will come when it will be executed. Here in the case, rule 6, statutory rule has not been complied. If a statutory rule has not been complied, my lord, whether action of the executive contrary to the rule can inure to the benefit of the petitioner, my lord?
Yes.
Rule 6 is there is no permission. And without permission, my lord, if your lordship will see the language of the commissioner also, when he has said that, kindly see that letter which commissioner has placed after misconstruing your lordship's order, which is there, my lord, page 52. Your lordship will see what is page 52. The order is completely erroneous, illegal, and on the face of it is against your lordship's order. Kindly see. The Honorable High Court, while passing the judgment so and so, after writing, has directed petitioner to approach the state government, that is Transport Department, with an appropriate application within a week, which is to be considered expeditiously, preferably within a period of 1 month from the date of receipt of certified copy. The Office of Commissioner Transport, Shillong, thereafter received the copy from petitioner which has been processed and forwarded to the original to the Transport Department on so and so. Therefore, and then it has been only processed and forwarded to the Transport Department. My Lord Commissioner is not saying it has received the permission, and the last paragraph of the order is itself clear. My friend is aware of the rules. My friend's client is aware of the procedure. My friend's client is aware of the judgment which has been construed by the Lordship in 2009, interpreting these very rules 4, 5, 6 and 7, my Lord. Therefore, in order to comply to the direction, now what is being done? This is being done to comply to the direction contained in the Honorable High Court order. I put that question to myself: where is the direction in the order of your Lord? Is hereby directed to pay challan so as to enable signing of the agreement for so and so. So he is signing the agreement purportedly in compliance with the order, which is completely erroneous, illegal, and on the face of it, it is against Rule 6, my Lord. It is on the face of it, it is against Rule 6. rules, if the legal position is, my lord, is settled. The statutory rules are above the executive action, my lord. And can be no estoppel. What is being argued, in essence, what I have understood in law is that there is a estoppel because you have signed the agreement of June 22. So once you have signed the agreement, there is a estoppel against the government. Though it is contrary to the statutory provision, there is no permission and permission has not been granted. It is not the case. What is being said, my lord, I am a stranger, I don't know what is happening between government and the commissioner, and therefore I should be protected because there should be estoppel. Agreement has been signed and law of estoppel should apply, and this agreement should be valid.
For one thing, Mr. RK General,
yes, Lord.
The impugned letter, which is 14 July 2023,
yes, Lord.
is very cryptic.
Yes, now I meet that issue also, my lord. This is a statutory provision which says that permission is required to be granted.
No, it doesn't say. You have an informed agreement operation.
Yes, your lord. You will see 14 says that the permission is being granted.
Letter 26-23.
Yes, your lord. You will see the permission is, if the letter is, my lord, if letter will say that permission we are giving you up to this date.
Where the letter 26-23? You produce the letter.
I will just place my lord, page 30. First, your lordship will see.
No, where's this letter 26-23? Have you placed it in your affidavit?
26th.
You refer to a letter dated 26-23.
I will place that, my lord. If your lordship will see this letter, this order also.
26-23 was the letter. 20 June 23.
Yes, I will place that that letter also.
Here, just you have it with you.
I don't have right now. I will place. I will get it this letter today only, my lord. You are hereby informed that agreement for operation of weighbridge as conveyed by government in their letter dated so and so. So in this letter of 26/2023 is saying that the permission is extended up to 39/2023 only, my lord. I will place.
What's the reasons?
Your lordship, the reason is that permission renewal. What they are seeking is renewal. Renewal of the tender of 2017.
Exactly, but are the reasons contained in this letter dated 20?
Your lordship, the reasons are.
You have not seen the letter itself.
I have not seen the letter, but what I say, my lord.
You say so.
What I say, what I submit, I have not seen that. I will get the letter, but what it means, my lord, what it means, into my understanding, according to me, my lord, is that there is a permission granted time to time by the government, my lord. This is a permission by, this is a letter 20th June is a permission granted by the government. That's saying that this permission is valid up to 30th September, my lord. That is what I.
No. It says you have informed the agreement for operation.
You are hereby informed that agreement for operation of the weighbridge. Weighbridge is extended up to 39. So there is an agreement which the Transport Commissioner has signed with the petitioner, my lord.
So that you mean agreement, to say by this 3-line letter, you are rescinding the agreement. You are terminating the whatever contractual.
Now the question, which falls for your lordship, the contract which Transport Commissioner has entered is against Rule 6, my lord.
See, exactly.
If it is against Rule 6,
suppose there is a reason speaking order. Then maybe the court can appreciate.
Why I say so? Requirement of a speaking order in commercial contract is not there. I have the authority on that because this is a commercial contract where this is not a case where I am passing
it's not really a commercial contract also.
Because
there is existing. It is not.
It is a contract, my lord. It is a contract which I have entered with the private party, my lord. Being a statutory authority, I can enter into the contract. I have got direct authority of Supreme Court on this issue only.
You don't need to.
No, I don't need to
refer to the.
I need to say, my lord. I need to say under the rules that I have granted permission to you up to so and so date. That is what I have said. Your lordship will see in coming judgment, which coming judgment deals with this rule only. That this coming judgment, kindly see this coming judgment, my lord, on this particular proposition, my lord. Kindly see page 14.
What is the judgment?
The compilation, that compilation, my lord.
This matter is taking too long. I don't think.
Only, my lord, I have got 5 minutes. I will finish every point, my lord, immediately, quickly. Your lordship, kindly see page 13. Page 13, paragraph 20. since the executive instruction embodied, paragraph 20, Your Lordship got it, page 13, notification dated 11/9/2003 and 2000 rules are not under challenge. We proceed on the premises that the government had the power not to allow, maintain or operate of way bridges for commercial purposes without permission having been granted by the Transport Department. Whether the government really has the power to prohibit even installation, operation of the way bridges for commercial purposes, which Your Lordship has posed that question, without permission having been granted by government is a question which we leave open for decision in future if such question arises. That whether we have got those. Now, paragraph 21, my lord, is the Honorable High Court quotes Rule 5 and 6. Rule 5 and 6, my lordship, those rules we have placed, and then in paragraph 22, Rule 7 is quoted. So 4, 5, 6 have been taken into consideration, my lord. Now 23. From a combined reading of Rule 5 and 6, what surfaces is that proposed place for installation and operation of way bridge on national highway state following conditions. So conditions are also enumerated. And 24, my lord. Rule 6 make it clear that Commissioner of Transport is satisfied that application for installation, operation of way bridge is complete and meets the requirement of Rule. And 5, he shall forward the application with all requisite information to the Secretary of the Transport Department for issue of permission. Under Rule 7 makes it clear that once permission is granted, it is renewable every 3 years. The only condition being that permission cannot be granted or renewed unless proposal for grant of renewal is accompanied by a certificate. Those requirements, my lord. So the point which I am trying to emphasize, my lord, is that without permission, Rule 7 can't come. That is the finding of the Honorable High Court and a division bench of the Guwahati High Court, which is predecessor High Court of this court. And in my humble submission, this judgment is also binding on the petitioner and me, my lord. 26.
Yes.
26. What is, however, of paramount importance is to note that unless permission was granted under the executive instruction aforementioned or granted under 2009 rule, it's not only with regard to executive instruction or under 2009 rules. Since after 2009 rules have come into force, the question of way bridge being installed or operated by parties does not arise at all. Granting of permission under 2009 rule 2 is therefore sine qua non for installation and operation of way bridge, and consequently a lease cannot be granted unless permission is granted, or lease cannot be renewed unless the permission itself is renewed. So my submission, my lord, is that permission was not granted. I have said so in my counter affidavit in clear terms, in unequivocal terms, that permission has not been granted. That fact has not been denied. The submission which is being made by learned counsel is, my lord, that it is between government and the Transport Commissioner. It's none of my concern. Therefore, once lease is executed, I will presume permission has also been granted.
I never said so.
So if it is not said that permission, therefore my case is that once permission has not been granted, that lease is void. Lease has got no legs to stand. That permission has got no legs to stand, my lord. That is
but one thing, Mr. Advocate General.
Yes,
suppose non-grant of renewal permission, it has to be based on certain criteria, correct?
No.
Now, is he given a chance to? Now he's already running the way bridge now.
Yes, sir.
So renewal permission under Rule 7 is automatic if you fulfill the criteria.
Yes,
now, are you saying that he's not fulfilled the criteria of having that integrated way bridge, that permission not being renewed?
I got it.
Is that what the government?
No, what the term, what is falling from your lordship is that before taking a decision, before taking
a decision of not renewal permission, is he entitled or not to a hearing,
to be heard,
to correct whatever deficiencies he might have?
Yes, lordship.
Because the fact remains that you've given him permission, you've given him the lease, he's running happily.
I have given him for 3 years up to 20.
Right. Now you mean to say that the deficiency, if permission is divorced from the lease, okay? We divorce for a time being, for the sake of, just understanding the matter, we divorce the permission from the lease that the government enters with. Now, non-renewal permission means he doesn't have the right to operate a way bridge.
Yes, sir.
And non-renewal, that means that he can enter to an lease agreement, or even if it's been renewed, that means it's on a misunderstanding or
mistake of fact,
compliance of Rule 6. Correct. Now, but suppose and situations that it demands that if you're not going to renew his permission, he's not entitled to.
Yes, sir, lordship.
He's not entitled to a show cause that that your renewal is rejected because it doesn't meet these conditions.
Yes, my lord. Now the issue is that he meets all the conditions. Question which is arising for consideration, your lordship consideration, is that a party has been given contract for 3 years, and then government takes a decision. And government takes a decision.
He has met the
conditions, and he meets all the requirements. Yes. Party meets all the requirements, and then the government takes a decision not to renew. Whether at that stage, whether hearing or PNG requirement of principle of natural justice.
No, that's just on what
material? On what material?
You are not renewing the permission.
What material we have not renewed the permission? That is the issue which because now in my humble submission I have two way to answer this query, my lord. One is that the contract was for 3 years. The contract, it said that contract did not say that you are entitled to renewal. Your entitlement, because if I have to give him,
forget before that part.
Yes.
Now the thing
then I will
go by your rule 6, rule 7.
Yes.
Okay, if I remember correctly.
Yes, sir.
It says that now permission is granted once, right?
Yes.
Then the right of renewal accrues.
Yes.
Subject to suppose only the inspector weights and measures and legal metrology says something that they're doing hanky panky, and so then maybe permission can be withheld.
No, your lordship, this judgment, Kameng judgment also, the renewal was denied. In Kameng judgment also, renewal was denied.
On what basis?
On the basis is that even if in the public interest I can deny him the renewal.
Exactly.
Public interest I can deny him the renewal, my lord. Now the public interest, so the question is that this is the discretion which has been exercised by the government is correct or not. In the facts and circumstances of case, your lordship would judge the case. Your lordship has posed a very pertinent query at the beginning of the argument. Your lordship has said that look, this is a commercial contract where you have got the contract in tender in 2017. Now we are in 2013. We are sitting in 2013, and if I go for a fresh tender now, definitely public the exchequer will get higher commercial value. So then if
see Mr. Archival General, leave aside that.
Yes, Lord.
We understand whatever your business.
So even assuming
what the thing is, that is the manner in which you yourself have
the manner is
this whole thing.
There is
firstly on the renewal, which
renewal
is
not
wrong. Happy at all. Then number 2, even the termination also, which is
I have, my lord, the only thing is what has happened that there was no permission. Absolutely, there was no permission. Without permission, this way bridge has been operating in violation of Rule 6, my lord, since 2020. And then we have regularized it by saying that look, we will give you permission.
There was never any renewal after 2020.
Your lordship, your lordship, see the letter. You kindly see the letter.
After 2020 is no renewal permission.
No, your lordship, kindly see the letter annexed with the writ petition.
I think we'll do one thing. This deserves more hearing. We'll pass some interim orders, at least for a time being.
Only thing, there are 4-5 considerations which should weigh with your lordship.
It's not dispose of this whole thing, but it appears that
your lordship,
much more than what meets the eye.
One thing, if I can clarify, your lordship. Now, my landed friend, time and again, he is saying Kamal and Suya, my lord, there, my lord, only the lease subjects of a general terms and condition, not permission. So a separate permission is required. My case, my lord, I am relying the fast agreement. If your lordship, if I can take, my lord, again, your lordship.
No,
my lord, only the page 36. Page 36, what is saying?
It's a commercial contract, my lord. It's a commercial contract. Term is over. He is relying on the order of your lordship to say that my lease is valid lease. My permission is a valid lease. It's a commercial contract. He has already enjoyed this property for 2.5 years without proper permission under the Rule 6. If I go for tender, my lord, I will get higher sum, my lord, higher return, my lord. I have got a recent judgment of the Honorable Supreme Court on this issue, that in these matters, how the writ court should approach, my lord. This was
my lord, I have to make my submission statutory incorporation.
Rendered recently only, my lord. If your lordship see Tata Motors, may I pass the judgment, no? Already.
Only problem is that I can sit till 4. I'm running a fever. That's the only problem.
Oh, I'm sorry. So, my lord, we can have it any other day, my lord.
No, we'll pass some.
Your lordship, we can have the hearing any other day, my lord.
The 30th is.
Only thing, my lord, 30th is 14th July. They have received the letter, my lord.
2nd September.
14th July. is the date on which they are having the knowledge, my lord. And they are coming to your lordship now in September.
Now, what's the operative part?
Yes, your lordship will see paragraph 42. Analysis start from paragraph 46, my lord, 46, then 48, my lord, 48. The court, being the guardian of fundamental right, is duty bound to interfere with there is arbitrariness, irrationality, malafide, and bias. However, this court has cautioned time and again that courts should exercise a lot of restraint while exercising their power of judicial review in contractual or commercial matter. The court is normally loath to interfere in contractual matters unless a clear-cut case of arbitrariness or malafide or bias or irrationality is made out. One must remember that today many public sector undertakings compete with the private industry. The contract entered into between the private parties are not subject to scrutiny under writ jurisdiction. No doubt the bodies which are the state within the meaning of Article 12 of the Constitution are bound to act fairly and amenable to writ jurisdiction of superior courts, but this discretionary power must be exercised with a great deal and of restraint and caution. The court must realize that limitation and havoc which needless interference in commercial matters can cause in contracts involving technical issues, the court should not even reluctant because most of us judges in robes do not have the necessary expertise to adjudicate upon the technical issues beyond our. The court should not use a magnifying glass while scanning the tender and making very small mistake appear like a big blunder. In fact, court must give fair play in joints to the government and public sector undertaking in matters of contract. Court must also not interfere where such interference will cause unnecessary loss to public exchequer, my lord. My case rest on this part, my lord, that it will cause, and then 52, my lord.
Yes, but then in contractual matters, courts not interfere unless if the orders is not visual malafide,
yes,
or patent arbitrariness.
And your lordship has seen. Your lordship has seen.
Even Mr. Alfred, you don't even well instructed on what basis the letter you don't have in your possession.
Your lordship, that is my mistake, because what I thought is that it is a permission by this letter. By this letter, the Transport Commissioner has been informed that permission is up to 30th September only. That is what I construed that letter, but I will get that later. What I say, my lord, is this: that this is a commercial matter where it involves if the license is not renewed, we will go for tender. He is free to make the bid. He will get and your lordship, if there is in commercial matters directly, if your lordship has seen that there is no requirement of principal, what your lordship is saying that in contract, whenever I terminate the contract, I give him the so-called.
See, if I can just see the mind of the court is this: court will not interfere in these commercial matters.
Yeah, I understand.
He is essentially seeking specific performance.
Yes, sir.
Of the later agreement which runs till 2025.
Yes, sir.
But there are the attendant facts which come together with his prayer.
Yes.
Which are totally there. You are not able to give me answers.
It's my fault also. It's fault of my government department also. How they have construed the order of your lordship. That is, and this will not happen unless, my lord, I said unless there is some sort of collusion.
See, and then whether the person who you have made your own bed.
But your lordship, when it comes to private interest and public interest, your lordship will surely weigh in favor of public interest.
Only one thing, Mr. Sen, now your renewal is up to 30th September. Your renewal fee is only up to 30th September only.
Yes. Allow me at least the first installment. In the meantime, lordship will decide.
No.
Your lordship, what I say, your lordship, is that even if I place that the other lordship is not well, I can place those judgments tomorrow.
One thing. You can have it tomorrow. We will pass only interim orders. I will not pass final orders because this matter needs deeper. Tomorrow is 28th.
Yes.
Lordship, I have got
no,
some.
I don't know. If I can suggest your Lordship's.
Because what I say is that
the only thing is that if we give you interim orders to run the beverage until the matter is heard, it will be heard in a week's time or 10 days' time, and orders generated. The thing is that for the intervening period, what should be the arrangement?
Your Lordship,
suggest
your Lordship has seen without permission, he has been running the beverage. In 2022, the permission has been granted. In 2020, there was no agreement. 21, there was no agreement.
Mr. Advocate General, you are allowing him to run the 39, 2023. That means it is understood that he has that requisite permission to run the 39, 23. If he runs it for another 2 weeks, what is the problem? What will be the arrangement for the revenue?
No,
That's the only thing. For a 2 week, you give a suggestion, we'll pass orders tomorrow. Only on that point regarding revenue.
No, only thing, my lord, even if he's running after 30...
I'll do some research on my own also.
Yeah, Lordship, kindly see, I have got some judgments on that issue because I did a lot of research on all these aspects. These are the citations.
You kindly give citation.
And the books are...
tomorrow, but just you come up with a via media how for a two weeks.
Only problem, my lord, is that I do not want to set the wrong precedent. Why? Because, my lord, there is in this case, admittedly, Transport Commissioner has acted without permission, and he has acted in violation of Rule 6.
Are you implying that it's a sovereign action on the part of the Transport Commissioner?
Yeah, there is no sovereign action. That is why there is no vested right.
Sovereign action means sovereign action means that he has taken a decision which is totally not in consonance with the department. Sovereign action means action on his own.
This is an action on its own. That is what we are trying to say, my lord, and therefore I can't. My difficulty is if then I have to condone his act. I have to condone his act.
Matter tomorrow. You just come up with a via media for 2 weeks. How will it run? Then we'll have
Better will come up tomorrow.
Yes.
No, my lord, my London friend is saying so many things. I could not at the time of.
No, we have to pass interim orders.
No, what I am saying,
because 30th 9 you're running. I thought that on your prayers they said that we will have the whole matter is not so long and we will dispose the whole matter. So court also said okay, fine. But then if we're going deeper and many questions are coming out, then we already said enough time.
Because I will place the law on the estoppel. I will place the law on everything. I will place, my lord, that authoritative pronouncement on this issue will definitely help. Because every day I see in CAG report
about sovereign action.
It's a sovereign
action. See, there was a case before. It's just to give an example. Now this forest officer, he seized this timber logs, right?
Yes.
He seized his logs, which is totally against the Forest Act. The way he went about it.
I have that judgment.
And then what was held?
It was held that
it was sovereign action on his part. You cannot attribute his action to the department.
I have that is the judgment. Supreme Court reported direct judgment is there, my lord. I have brought that judgment also. I have brought that judgment also.
Lordship, my lord, at least I was expecting. What is that order?
They are saying that they bring that he acted totally, in.
No. Then your lordship, my lord, at the time of filing I could not. My lord, I have obtained a copy of the order of the government. My lord, I'll just file a small affidavit also. Now, what it say? Addressed to the Commissioner of Transport. I am directed to forward here with the letter dated with the actual Government Advocate Meghalaya High Court Shillong, which is requested to take necessary action to the order of this court. These has the approval of the competent authority. I'll bring it on record, your lordships.
Please get a letter 20th June.
I will get it.
Yeah, tomorrow. This is matter tomorrow for further hearing.
Lordship will decide it tomorrow. No, some
it's a very interesting matter.
Lordship, I have time to, because I can't condone the act of the officer who has acted completely against the rules and provisions, and that forest judgment is in my favor.
Yes, so that's item 21 and item 1.
Item 1.
This motion. Very interesting case, one. Because it's a real kitchen, yes. Yes, Dr. Mozika, you see in office noting, you don't have the steering committee resolutions on which you have challenged.
Malad, because we don't have access to that, Malad.
Okay. But then Mr. Kurishi will answer your question. Malad, yes, what are we submitting?
After the general body meeting, a steering committee was formed, and the steering committee, through the principal is a very important person in the college.
Who are you?
He is the only one. Yes, principal. It is the principal who has submitted the.
Please.
Bring them along with you.
Page 12, Lordship.
21 we do not file.
Chennai, come along.
Page 12. Page 12, after the
Yes.
The decision of the steering committee was forwarded by the principal to the Director College Development Council, Nehu Shillong.
Where's that? Where's that?
Is a page 12.
You're aware of this?
My lord, because we have not received a copy of that petition.
No, in this case,
my lord, what I am praying at this stage, my lord, if I may just point out a few documents from my petition, my lord.
1 second. Let him start.
There is that. So the principal is the only authority. After that, he submitted the letter to the Director College Development Council, Nehu Shillong. The Nehu Shillong.
That page 12 is in order.
Page 12 is the letter forwarded by the principal, and it is forwarded to the Director Higher Technical. Then it has gone to the Director College Development. Then he has acted.
Have you seen a copy of this, Mr. Mosika?
No, my lord, I have not.
You just give him a copy of the petition and have it tomorrow. Then we'll know. We'll dispose of both these matters.
If I may assist, my lord, the general meeting proceedings dated 16th is not on record at all.
Tomorrow.
That's
yes, doesn't matter. Tomorrow.
The director has to take decision.
No, like you get a code petition. It's the same college.
Same college.
Hearing?
They have come for approval. We are objecting to the approval, my lord.
Hearing? Item 23.
23.
My friend Mr. Ganguly is on the other side because I don't see him online.
We'll have some other time. After 1 week.
After 2 weeks, Mills.
After 2 weeks. Yes. Sorry.
24.
Lordship, it's okay. It is summarized on sensibility, Lordship. I'm paying 1 week time.
After 1 week.
Connected to 25.
As the arguing counsel, we have responded and sanctioned. 20. This is now 24.
25. But your Lordship, short date may be given because argument is over on our part.
But remember any arguments?
This is the 5th time, I think.
Obliged. So at that time you had a chance to finish off the hearing. Don't take time again to come up with instructions and again these court forgets. You finish it off, finish it one shot.
26.
Lord, I seek permission in this case to view records from the moment, my lord, which is only recently come to my notice. To file an application for seeking permission.
To do what?
Recently we came to notice, Lordship, there is some development.
What development?
At this stage, my lord, second appeal.
So, but we have, yes, we want to bring or record one document, my lord, which is very vital for the disposal of the matter.
It's not part. Is it part of the record before the lower appellate court and trial court? Was it part of the record?
Portion of it is a part of the record.
Then we won't allow that.
Portion of it is on record and a portion is not.
Okay, at this stage, my lord, second appeal.
You just produce that letter. We will not take it. We will not take cognizance, but we'll just examine it. We will just have it after 1 week.
Yes, that.
Yes. The Prem CSCD is a matter of the 1 week. We will not say for what reason.
28.
But this will require some time. So we can.
Where's Mr. Abraham?
Yes, sir. Also, will take it today, or we can have it tomorrow.
Today, sir. We'll take it.
Tomorrow, Mills.
Wait, somebody tomorrow? I don't know.
There is an interim order operating, Mills. That is the
next week, maybe on 30th.
Interim order still.
Your Lordship, sir.
Sorry. 30th is a Saturday.
That's why it's a little.
Yeah, I mean 30th is Saturday, then
30.
It'll be on 4th. No, sorry. It'll be on 3rd.
Well, third and fourth, I'll have a little difficulty.
Then 5th.
Fifth.
Doesn't matter.
But the interim order.
Interim order could next day. Does teacher matter?
Well, this is regarding a school managing committee, but subsequently, some interim application has been filed, under which your lordships has been pleased to stay the recruitment process.
In the last month of the tenure, they issued advertisement. We've come against that.
That is not the subject matter of the writ petition, that is my limited case, because
anyway,
next week your lordships may come.
5th, sorry.
29 may be taken together. It's the same magic committee.
Is from where? Rajabala? Or from Fulbari? Same area.
It's actually reflected in the order, that there are two other writ petitions. So may I pray, all of them be taken up together?
Yeah. Just give the numbers. Yes.
30.
Records are received.
In this case, my lord, a very short question is my lord, whether the sister of a Khatu is entitled to stay in the.
We won't have this today, but we'll have it after 1 week. It's a very important question.
Yes. 31.
Lower court records office note indicates that lower court records have been received. This is matter for hearing after 1 week. No, the records have just come also.
31.
Yes, Mr. Yubin.
31.
Sorry. Yes. Yes, Ms. Wala.
Case 31.
Please, Your Lordship has been instructed by the leading counsel of respondent number 4 that the counsel is indisposed since he got
He met with an accident while coming to the.
Today?
Same of no spoke.
With the learned counsel for the respondent for.
Oh, learned counsel?
Yeah, I mean action today?
Yeah, I think while coming.
Okay, as the counsel is going to force him to have met with the. Is he alright?
We don't know. We don't know. I was following also.
We don't accident. You following him when you got an accident?
No, we came to know about the accident.
Oh, he said I was following, sir.
Today there was a cloudburst. It was a very bad one. I was stuck in a flood while coming from home.
As the constable who said it met an accident on the way to court, this is a matter of 2 weeks, yes.
32.
After 2 weeks, Your Lordship?
After 2 weeks, okay. Yes.
Highly obliged.
May it please Your Lordship. Your Lordship, before we start the hearing,
this matter will take some time.
No, in my prayer, I've also prayed before this court to call for the records of the inquiry. Because of the inquiry commission.
You've annexed the.
I have annexed the my lord, what has happened here. I have annexed the copy of the inquiry.
Since the reports already there with the
report, my lord. Here, what has happened now? A very we have come to learn now what has happened. The persons who had taken part in this operation, the tactical team 1, these persons have been promoted from constable to SI also.
So they have been promoted as per.
Just see the
has taken place.
No,
as per
because
law,
what I'm trying to say, we have filed that.
You mean to say that those constables, they're the persons who were directly responsible for the incident?
Yes.
What I say,
that speaks a lot.
What I say is that, my lord, if I can show from the admission made by learned senior counsel in the inquiry commission that the action was required, the action was needed, and there are ample materials which are there in the inquiry report which justice.
No, Mr. No, we won't call for the records because then that will digress the entire.
Your Lordship, the prayer
what you want here is that we hand it over to CBI.
Yes.
Correct. So the only thing is that you have to satisfy this court that whether materials exist that that
yes, because
that the action of the state is not
no, because the Supreme Court has also said that this court will have to go into the pleadings of the parties. Now, Your Lordship will see the affidavit filed by the government. They're completely silent.
I am not
regarding the FIR. Let me submit.
Please wait.
Yes.
Lord, we have made specific allegations in paragraphs 4, 5, 6, 7, my lord, 8, 12 and 13 and also 20, 19 and 20. Now these have not been answered at all. By the state government.
At the time of hearing, Lord, I'll show what we
by
have
the state
answered.
by the state government. So which implies that these are admitted.
And so we have answered to
No,
each
one
and
thing,
every-
why you want records of the inquiry? Inquiry report is there.
Well, inquiry report is there, but what has happened before the commission was that the names of those persons who took part were not disclosed.
It was disclosed to the commission.
To the commission, yes.
It was disclosed
to the commission, yes, but not to the public and not to us also.
For reasons, obvious reasons. We
Can
did
you
not do.
please allow me to
Sorry.
comment?
Yes.
Sorry.
Yes.
You have this habit of
Wrong habit.
This is part of advocacy, to have to heckle.
Your Lordship, I'll just want
Yes.
to take to Your Lordship to the findings of the commission.
If the Lordship is sharing the matter, I'm ready.
No, the thing
No,
is
what I'm saying is why are the records?
Because you see, the thing is that, as you well know, you've been in many commissions.
Yes,
also.
yes.
With regard to, because to the personal safety of
Yes,
certain
of
people.
the-
That is why even in some cases they're even brought as witnesses also, and some that forget about the names being divulged. So anyway, circumstantially, whatever what happened, that's the only thing. But this court at this stage, I think, would not call for the records, because your petition is specifically only for that
CBI
satisfied.
investigation.
He is not satisfied with the investigation and the proceedings which is being handled by the CID. It's by the CID.
By the local police.
By local police. So that is why. So you have to show in which way.
No, but that is one reason also. No matter what, instead of instead of proceeding with a criminal case, here persons who are involved in this incident have been promoted. Let them deny.
Your Lordship,
I'm bringing it to the notice of this court. This is the conduct of the government.
Do you have tangible information on that?
Yes.
How do you know the names of those people?
It has been known, sir. It is known.
It's not known to me also.
It's not known to them also, but it is not. It is known.
Of those people who are involved in that.
If your Lordship desires, we will file an affidavit also. But at this stage, I don't want to divulge. But this is a very serious issue. Now, how can we expect now the local police to investigate the
Your
case?
Lordship, this matter has been, with respect, this matter has been gone into in detail. Each and every witness has been called. Doctor has been called. The detailed commission of inquiry report is there.
No, but you see, one thing is that the inquiry commission has found that there's been use.
Your Lordship, it is not. If I will
Let's
show
see,
the
let's see,
findings.
let him please inquire.
Yes, I'll just
we'll not
please-
conclude the hearing today because
Yes,
because I'm not in a.
It's not well.
Well,
Your Lordship, not well.
I'll just bring your Lordship's attention to page 47. 47 towards the last 4-5 lines. In my considered view, the operation was well laid, planned, but poorly, recklessly, hastily, and without proper application of mind. In other words, it was a botched up operation, and failing it in its objective of apprehending the deceased alive, who could have been given valuable information to the police about the subsurface actions of the proscribed HNLC outfit. The fact that by undertaking such reckless operation, the team completely lost sight of the possibility of harming the family members of the deceased, who were never accused of having anything to do with the nefarious activities of the deceased he was charged of. If the primary objective of carrying out the operation was to capture the deceased alive, the manner in which the raid was conducted unnecessarily gave rise to the impression that was not so. This is most unfortunate. Now 33, coming now to the killing of the deceased. In fact, the commission has used that word.
No, it's okay.
34. My lord, will come to page 49, para 34. In my opinion, having entered what could possibly be a lion's den in darkness without proper planning and without taking adequate precaution, State witness number 4 had taken purely avoidable and unnecessary risk endangering his own life and that of the deceased, whom the team professed to have not intended to kill him in the first place. In my opinion, the forced entry into the house of the deceased in darkness and the subsequent killing of the deceased was a reckless exercise and tantamounts to disproportionate use of force, which resulted in the death of the deceased. This apparently defeated the very purpose of launching the operation, namely to capture him alive. The deceased was never apprehended alive. It was thus a futile exercise. Had they waited for about 2 hours or so to let the daylight to emerge, cordon off the house of the deceased, as they actually did it here, in the meantime, and lobbed tear gas grenade into the rooms occupied by the deceased and his family, they could have been forced to come out of the house. The deceased could have easily been apprehended by this means. In this way, the safety of the other innocent members of the family of the deceased could also be ensured. In my considered view, the post facto excuse that none but the deceased was hurt cannot be a valid justification for carrying out the operation hastily and in a reckless manner by the tactical team number 1. Therefore, my finding is that the tactical team number 1, in carrying out the operation to arrest the deceased at his residence on so-and-so, was culpable of thoughtless and excessive use of force, which resulted in the death of the deceased, late so-and-so, which turned out to be avoidable. Here, this is very important, my lord, 35. Both the learned counsels appearing for the state and the family of the victim submitted the respective written arguments, which are annexed here to respectively, and raised a number of contentions to support the respective cases. But as already observed by me elsewhere, I do not propose to burden this report with such contentions in view of my above findings. For example, I do not propose to discuss the other witness evidence available on record to determine as to whether witness number 4 mouthed down the deceased intentionally or in self-defense, since the material I could derive from the statements of the 3 state witnesses are sufficient for me to arrive at my above findings about the culpability of the tactical team. In the manner in which they carried out the operation, the remaining issues are best left to the jurisdiction of the criminal court to decide. Well, in fact, the Commission of Inquiry did not go into the aspect of the post-mortem and all that also. It said just the evidence of the police officers is enough to show.
Yes, excessive force.
Yes.
Yes.
May I please?
So there are other records, my lord, before the Commission, which will also lend credence to the fact.
No, you have to show, Mr. Dingdo, that the police have been inept. Now, one of the things that you see instead of where the recommendation says.
Recommendations are, yes. Recommendations by these are different. But what I'm saying, what are the findings? The finding of the Commission per se is that the deceased was killed.
Yes, of course, that is a given.
Whether it was, as I've read, whether it was in self-defense or not, that has to be gone into by the criminal court. Now, my contention is that we have filed a FIR since.
What did they say in the affidavit with regard to progress investigation?
Nothing. That's what I've pointed out, man.
Then the records of the course or case diary of that Mola PS case.
Yes.
Your Lordship, I'll place it. There is no problem on that. But Your Lordship, kindly.
Let's hear him.
Kindly give me 2 minutes, my lord. Kindly see the finding of the Commission of Inquiry, which my friend has read out at page 36. Page 36. After, my lord, each and every witnesses have been examined, and then Your Lordship, page 37.
Yes. Okay.
37. As the decision to cause arrest of the deceased had been taken, there is no reason to cast doubt on the statement in respect of the above information.
Where are you reading from?
I am reading 37 at top, my lord.
Top says,
there is no reason to page 37, my lord. The blank part is there, page 37.
In my opinion.
In just above my opinion, my lord. 3 line, just second line of page 37.
Yes.
There is no reason to cast doubt on the statement in respect of above information. In any case, learned senior counsel also does not raise any issue on aspect of the matter. That is with regard to conducting raid, my lord. In my opinion, the inputs received if on the facts and circumstances of case are sufficient to him to take a decision to arrest the deceased. After all, it is not necessary to establish beyond reasonable doubt, unlike a criminal trial, that deceased was definitely involved in the criminal activity he was charged with. He could definitely decide to arrest the deceased ipso based on the above inputs and surrounding circumstances.
Just one thing.
So
This is the mind of the court. We're not into his inquiry. We're not into whether he was killed. The thing is that only what has happened after an inquiry,
yes,
number one. And number two, what happened to the Molaj PS case that was...
I will answer this, Your Lordship. I will answer this.
Because criminal trials are
two
different
facts
thing.
are there. Before Your Lordship, there are two facts. One, the raid has been conducted.
Yes.
The police has raided the house. That fact is established, my lord. The police has reasons to raid the house and to make effort to arrest the deceased. This is the second fact, my lord. Third, which is coming out partly, that probably we should have used the tear gas or we should have deployed some other means to arrest the person. That is what the Commission of Inquiry says. In recommendation, there is only recommendations that these are the precautionary measures which are required to. Now, before Your Lordship, the complaint, the repetition.
You mean to say that the finding of excessive force does not require any further inquiry? Any further action by the part of the state?
I'm not reaching to that conclusion. What I say is that now there is there are certain conclusions which have been reached by the Commission. Those conclusions will be taken into action taken report that will be placed in the assembly. Now, the excessive force in this case is that the person tried to make an arrest, the tactical team number 1, and it led to firing and it caused death. Now, this was in discharge of official duty, that is not in dispute. This was carried out in discharge of official duty in these circumstances because perception in hindsight.
No, that is why that will come in a criminal investigation.
No, Your Lordship, I have come out with the criminal investigation. What material which they are saying is that if I have gone and picked up some person and shot him dead in road, street, etc. There are material to show that he has got the criminal incident. There are material to show that he was involved in the IED blast. Those findings are in my favor. So, and he was planning to explode bomb on 13th or 15th August of that year, my lord. Those materials have been taken into consideration by the Commission of Inquiry. Now, so far as operational aspect is concerned, there are two parts, my lord. One is the decision to arrest him and second is the operational part. Now, operational part, my friend is complaining that there is an excessive force. There is an excessive force which my friend is complaining. This is, if assuming for sake of argument, I am admitting, my lord, that there was an excessive force, my lord.
Yes.
Whether that excessive force will make those persons who are involved culpable in the official discharge of duties, my lord. They have to show excessive force with motive, intention. Where is that material? That there was whole and sole material to do that. My lord, in these, I have got series of judgment on this, including that Vikas Dubey encounter, my lord. That is also there, my lord. So therefore, this requires...
An encounter on the roadside?
Roadside, my lord. And that encounter on the roadside, your lord knows that such... But what I have got those materials, my lord. What I would urge your lordship to hear the matter on all aspects. I will place it.
On all aspects. Only that,
we are more
also have to satisfy the court. That what grounds they can establish that the court satisfied that with sent for CBI.
Yes, that is the parameters. That is the parameters on which your lordship has to.
His prayer is basically the prayer. The prayer is that.
Prayer is that. Prayer is that. So therefore,
investigation of the PS case by the CBI.
Then therefore the burden is on my friend's client to show.
We have made statements.
They have. If I make the statement, then CBI inquiry can't be made on the basis of statement. They have to show that
we don't need Supreme Court
something more than
judgment, my lord.
So
your
something more than
something the other day itself has upheld.
Something more is required.
Judge judgment regarding it's a very similar case.
Something more is required.
Very similar case.
I'll place the facts and everything.
We don't need. This is the case of Mingran Tisama, upheld by your lordship and the chief. This is from the judgment and order. Abal Sangma case.
Okay.
Yes. The very same. In fact, in this case, my lord, the first press statement issued by the government was that the police had acted in self-defense since the the deceased, he had tried to attack them with a knife. That was the first press statement which was given. Now, neither was the knife exhibited before the commission. That's why the commission also. It was never exhibited before.
The Abbas Samar case you just get is because that the gun is supposed to have shot it.
Yes,
it's rusted.
Same thing. Here also, it couldn't have been. Here also, the police claimed to have seized a gun from the house of the deceased also, which is a rusted pistol.
Also, ransom call also. There are so many materials.
But
Everything
only a criminal.
Even then, ransom call, whatever. But will it warrant that you kill him in cold blood?
His Lordship, there I can't argue with my friend that.
Another statement, of course, the commission has not taken this to.
We'll list it after 2 weeks.
My lord will call for the case diary of the Maulai PS case.
Let him. Yes. Let him come up with affidavit. You can show that this affidavit is not.
They have done something.
I have got the report. I can place it before your Lordship.
What report?
A report of Moblai case. I have got that. If Lordship wants to peruse,
They have
I
to
have
close
got
it by way of
because
an
the
affidavit.
report-
We have to know
because
also.
I can't disclose it to what is happening, what is the inquiry, because this is the for
But we have every
satisfaction
right.
of your Lordship.
We have every right also to answer.
That is satisfaction of your Lordship.
This was filed when?
Mr. Kupiya. I don't know. If they are not, the inquiry is being conducted as per law, my lord. There is nothing.
So all the statements have been recorded from your family. Yes, your family and also.
And CFSL reports are there. Everything is there, my lord.
No, but has been sent to forensics.
Forensic also. That CFSL report has also at the bottom. I have seen every day. Pink one, my lord. Pink one is also there. And there are certain facts which are not in dispute. My friend is also saying encounter has taken place. I am also saying encounter has taken place.
Yeah.
I am saying that encounter was required, warranted. It was in discharge of official duty. My friend is saying that no.
Now, Malad, as I have stated, now the accused person has been promoted by the state department.
They are challenging promotion order. Let me challenge promotion.
We will bring an affidavit.
No. The thing is, in the course, unless there's some conclusive findings, then they can,
But conclusive findings of the commission are there, and we want a proper inquiry, Malad, because the CBI is going to go into the motive.
You take it back for a time being.
Yes. No, but this CD can be, Malad is very well aware. A CD can be made at any time.
So now, first they wanted CD.
But
CD has come.
But whether CD by their CD,
no, we'll have
this
it
court
after
will
2
be
years.
satisfied.
You satisfy the court?
Yes.
On that point, yes. On the play the parties after 2 weeks, yes.
Item 33.
The case you did. The case series.
Also filing hearing. This is also for hearing, finally.
What happened? You filed affidavit?
You filed, man.
What do you say about the amount?
My lord, there are disputes with regard to the amount also, my lord.
You filed rejoinder also?
Yes, your lordship, rejoinder has been filed.
What do you say in rejoinder? What do you say in affidavit for Dr. Mojika?
Firstly, we have taken basically two grounds, my lord. Firstly, that we have not derived any benefit out of this, my lord, after the entire transaction. In fact, we have incurred expenditure in destroying the betel nut. And the destruction was done on the basis of a report given by the food laboratory, my lord, that is unfit for human consumption.
Was it destroyed pending appeal?
Yes, my lord.
And then? That means you have to pay the value of the amount of goods. But who has assessed the value?
My lord, that is the question, my lord.
Who assesses the value?
The value, your lordship, we are seeking the seizure value as along with the interest.
Seizure value is how much?
Your lordship, the seizure value is
because then payables at the time of seizure, Dr. Modika. If we put it very simply.
My lord, in fact, in one of the communications, they themselves admitted, my lord, that the value will be much less because of the quality of betel nut, my lord. Because there's a report.
At the time of seizure, who does the assessment?
88 lakh, your lordship, the value, seizure value.
Because Dr. Mazika, it was disposed of during the penalty appeal, correct? And after you destroy, a position to return confiscated goods anymore. So then you have to make good their loss.
My lord, that is the question. How much is the loss, my lord?
That is how much the loss. That's what the court wants to know. Then we'll pass an order that the petitioner be paid the seizure amount, which was fixed at the seizure. Where's the seizure memo?
Your lordship, it is annexure number 1, page number 25.
₹1 crore 22 lakhs. You're beating not 44. Yes, Dr. Mazika, see.
88 lakhs.
88 lakhs. One is 200 bags, each weighing 80 kilos. Total weight 16,000 kilos. And another also 200 bags, 80 kilos. 275 rupees per kilo. So what do you do? Say you take instructions to come back by the end of tomorrow.
What is praying? Because if a lordship kindly...
There's nothing to adjudicate any further in this case.
My lord, only question is, my lord, the determination of value, my lord. That is one aspect of the matter.
No, but I think decisions are there that say as per the seizure, but what will fix the seizure?
My lord, if lordship kindly comes to page 7 of the affidavit, my lord, which you have filed.
You have to make good the loss, whatever it is. Due process. What's 88 lakhs? Nothing for customs. With interest. Page 7, my lord. Subpara B. Yes.
That however, without admitting to the matter, for the sake of clarification, record it is submitted that as per order in original number so and so, passed by the Commissioner Shillong, in connection with seizure of 32 metric tons of betel nut white seizure note, it has been mentioned in para 41 that the petitioner Srimati Laltanpui, via her written submission dated so and so, has requested for provisional release of the seized 32 metric tons of betel nuts for non-consumption use and had prayed for reduction of price of the damaged seized betel nut at ₹96 per kg. They were also accepting the fact that the seized betel nut was unfit for human consumption.
No, that's different. That is out of the window. The only thing is that
they admit the value at 96 rupees per kg, my lord.
No, your lordship, that is not true. And just in case, your lordship, I'd like to refer to page number 4 of the rejoinder affidavit that we had submitted. I have a Supreme Court decision here, wherein the Supreme Court has said that in consequence of setting aside of the order of confiscation on the ground that it was illegal.
Page?
4, your lordship, of the rejoinder affidavit.
Yes. Where is that? Page 4. Okay.
Yes, your lordship. Yes. Northern Plastics versus Collector of Customs, Supreme Court decision.
Yes.
It says that in consequence of setting aside the order of confiscation on the ground it was illegal, the assessee has become entitled to the value of goods. And in result of the applications are allowed and the respondent is directed to return the amount of rupees 33 lakhs with 12% interest from such and such till the date of payment. Your lordship, in this case, it clearly states that the value of the goods, at least we become...
No, that's the only thing that isn't dispute now. No, the value, how should the... Where is it? It says as per the seizure list, where there's any judgment saying that? Any judgment says that as per the value at the time of seizure? Evaluation at the time of seizure?
My lord, what happens, my lord, at the time of seizure, my lord? Because there is some, as per customs duty, there are tariff rates, my lord. So valuation is given, my lord. That is the deemed value, minimum deemed value. without assessing the quality of betel nut value.
Exactly. I mean,
that's the value of 277.
where then, how do we peg the value? That's the only thing.
Well, that
You're
is,
entitled to that.
Yes.
Whatever the value is entitled to.
how to determine the value? That is the main question.
Your Lordship, in this judgment, it says regarding the value of the goods, it can be assumed that this means that the value of the goods during the time of the seizure. This is as per section 111 of the Customs Act. Confiscation of the goods.
But I'll come up with some more decisions next week something.
Because you have to pay, it's the only thing.
You have to pay, but how much?
You have to pay. In the course of hearing, the undisputed fact is that the respondents are liable to pay for the cost of the confiscated goods which have been destroyed during pendency of the appeal.
But that observation,
why?
In the final order,
Your Lordship.
After 1 week.
Your Lordship, I have a request. My senior, Endas Gupta, yes, he's on leave till 4th of October. If the matter can come up after 4th.
Okay, after 4th October. You get instructions.
Yes. Much obliged.
You come with other decisions also, whether the
Yes.
amount is regarding seizure amount that fixed at the time of seizure, whether that can be the, the standard for which you can, because they say 275 and you say 96 at the time of trying to get the return.
Yes.
Then if you can arrive at some...
Or they should approach civil court for assessment of the value.
That is true. After destroying their goods, you want to approach civil court for 20 years, yes.
Much obliged.
Yes.
34.
Okay.
My lord, 34 to 73 are contempt. If my lord may kindly take 74, item number 74. This is that matter, my lord, where we have been denied the NOC. But now my learned senior has pointed out in the last occasion that they are not the authority to issue the NOC, my lord. And also a submission, the CM.
See, the thing is that now we need, where's Mr. Kantar's assistant?
He's there, my lord.
Oh,
Senior counsel is there.
Yes. The thing is that you see, to put the thing in place, and because we have whatever's been done.
Yes.
See, why this thing happens that asking the CM, because of those meetings that were held between the deputy commissioner and with the traders and all. Now, if we have to do something, that should be in accordance with the statute.
Yes, correct, my lord. Correct. And we will follow that, my lord.
That's the only thing.
Yes, yes.
And so we have to, sort of recall all the early orders whereby the CM has been put to trouble, to examine all the documents and all.
Yes, yes.
It should come from your, immediate, whoever's the traditional head there, the NOC.
My lord.
Now the business is running.
It's running, all running.
No, the problem we are facing is
single
this.
day
The problem we are facing is this, my lord. Some of them, they have that, this export-import, my lord. Now, they cannot renew their GST.
Why?
Because the trading license is not there. Because in the portal, the trading license has to be uploaded.
In the portal has to be renewed? No.
Yes, my lord, in GST. That is what I've been instructed, my lord. They are finding it difficult, my lord. For shop, there is no problem.
Is that correct?
Yes, my lord. I have been instructed, my lord.
It has issued by the district council, has to be uploaded.
Yes, they say that some number has to be uploaded, my lord. Now, my lord, I am submitting on the instruction, my lord. I have no knowledge, my lord, but I have been instructed.
I don't think that is correct.
No, but I have been instructed, my lord.
Where is the DSGI? And maybe you can throw some light in GST whether, or it's already left.
Now, my lord, if my lord may kindly come to the order dated 6/9/2023 in contempt, my lord.
Omniscient 73.
6/9/2023. This is a common order which is passed.
Yes. Yes.
Yes. My lord. My lord, may kindly see the second paragraph if my lord is releasing. Mr. V.K.J. Kinta, learned senior counsel, who is appearing for the newly implemented respondent district counsel, submit that he is yet to receive a positive instruction. He also further submit that to facilitate expeditious disposal of the matter, the writ petitioner may be allowed to approach the district council authority directly for renewal of their license. That means, my lord, now we are not required to go to CM because
that is why, because in accordance with the act,
yes,
pass through the CM.
Yes.
Excuse me.
My lord can take up this matter some other day because my lord is not feeling well.
Dr. Mozika, is it correct now for loading up the GST portal, if you have a trading license, you have to upload that also?
The number of the trading license. That we was informed by our client that day.
I'm not very sure, I can find it out.
Just find out for the export-import license whether to...
The GST number is...
Yes.
Trading license. They have to upload a trading license. Yeah, because they are non-tribals, so they have to upload it.
In the GST portal?
In the GST portal. That is what I was instructed. They are finding it difficult.
The GST... Yeah, I don't think so. Does GST differentiate between tribal and non-tribal? I don't think so.
No, my lord, because the payment has to be made. If my lord see...
Yeah.
Both GST and ISC, my lord, because the amount is, there is an amount transaction, my lord. So they have to pay the GST first, my lord. For that, my lord, some number has to be inserted. That I was instructed, my lord. But I will also find it out from the trading license number, my lord. But I will find it out, my lord. That I was instructed. I'm not submitting that, my lord.
When should you have it, Mr. Kinta? If you
let it be on Monday, my lord.
If you can assist the court to the steps of which they taken in disposing of these matters, like the process which they can go through to simplify it. Because we can't deprive them, we can't fall foul of the constitution. They have the right to, and it's help the economy out there is dependent, they're age old, dependent on this.
They are also losing revenue because renewal has not been carried out.
Yes.
And for a long time they've been carrying the business. That is on record. And trading license will be renewed right from the day it expires.
It lapses. We are ready to pay.
There's a pertinent question also here, my lord. There is a very serious legal implication here in which all the writ petitioners, no license has been renewed in 2019 or 2020. All 10 years, 20 years, 18 years, not every year.
My lord, if it is the licensing authority who has to decide my license, can the CM raise this sort of objection?
Why not?
No, my lord, the law doesn't permit to raise. My understanding, the law
NGOs are going around and making money by harassing and exploiting people.
But that is for the respondent to take care, my lord.
We have been
Monday we can't have it because it's
Tuesday, my lord.
We are being notified as public authority, my lord.
Of course.
We are very responsible.
Tuesday, my lord. Tuesday
in No, Tuesday we can't have it.
Wednesday, my lord. Any date next week.
After a week,
Wednesday.
because
not after.
Lordship also appears to be having
By Wednesday, my lord, will be fine, I think. I'm full confident, my lord.
And after the compliance report, my lord, there is only one communication from the KHDC which would like to.
No, the thing is that because it is KHDC,
Yes,
actually
KHDC.
they should be more proactive.
Yes.
When these things arise, especially in the CM-ships.
I've already suggested that since the CM says that we're not going to issue NOC, then we have taken the idea that we should resolve this issue.
Yes.
But the thing is that the 3rd of August 2023, recently we received this communication from the KHDC, which if your lordship can just see.
It'll solve the whole issue.
And there are new, almost like that they try to resolve after the compliance report from last year. This is the only communication we received from the KHDC. And it seems there are fresh applicants are there also for trading license from Majai area. And they sought a inclusive report from us, which is very pertinent since we have no knowledge of these.
Okay, all that will come to court, no?
Yes.
Yes.
And even in the after the contempt in the writ also, 4 are new writ petition.
Okay, doesn't matter. We keep this with you.
We will comply with this.